on DEIS page 27.
According to footnote 2, includes restaurant uses approximately 15,000 square feet, specialty retail 49,000 square feet, and indoor event center spaces 31,000 square feet.
I just note, Mr. Norris, that adds up to more than 70,000. It adds up to 95,000, right?
Correct.
So apparently this breakout must refer to later phases of the project.
Well, the 1, 2, 3 refers to the different planning areas of the proposal.
Okay.
With 25,000 square feet coming under planning area 3.
Gotcha. Okay. Well, regardless of which planning area it's under, do you see any shopping center here in the breakout of land uses in footnote 2?
No, I do not.
Is there a difference between a shopping center and a restaurant?
Yes.
Is there a difference between a shopping center and specialty retail?
Yes.
Is there a difference between a shopping center and indoor event center spaces?
Most definitely.
Do these more particular uses have their own trip generation reports in the ITE manual?
Yes, they do.
And do they have their own pass-by rates in the ITE manual?
No, they do not.
Why don't they have their own pass-by rates?
There's no data been collected to support pass-by for those uses.
So then if let's say I'm building a restaurant or a specialty retail shop or an indoor event center space, and I want to estimate my pass-by rate, what am I supposed to do?
Well, I think to understand the whole issue of pass-by as an emerging analysis that's been added to justify questionable trip generation rates, but the actual data that's used to document pass-by is really still kind of sketchy and not really solidly confirmed. So caution is always recommended in the use of this.
Well, but is there data in the ITE manual for pass-by rates of, say, restaurants, for example?
Not for restaurants, no.
And for retail spaces?
There is for different types of retail, yeah.
So you could hypothetically include a pass-by rate for your retail use.
Hypothetically, yes. There's different kinds of retail that's identified, like discount stores and those kinds of things do have pass-by rates.
Okay. And what about indoor event centers? Do those have their own pass-by rates?
No, they do not, and they're not included in the retail category either.
So then if I'm building a land use that doesn't have a pass-by rate stated in the ITE manual, and yet I nonetheless want to, estimate how many trips I'm generating, what's the responsible thing to do?
Well, the ITE suggests that the analysts do a local study of pass-by conditions on different land use types, and there's specifications for doing that. Secondly, in this case, the use of the PSRC model would give us some reasonable understanding of pass-by because of the trip purposes that are in the model itself. The IT model, as opposed to, or not the PSRC model, as opposed to the ITE, ITE just gives a gross number of trips. It's no stratification of different trip purposes, whereas PSRC stratifies the different trip purposes, which allows a calculation of these interactions between internal capture and pass-by, which is not possible with the raw ITE data.
Is there any scenario under which it's a responsible decision to simply take a different land use, such as shopping center, and apply its pass-by rate to uses that aren't shopping center?
No, that would not be acceptable.
Would the use of different pass-by rates from different land uses have changed the bottom line figure in terms of like the total number of trips that the use is generating?
Most definitely.
And what effect would changing the bottom line figure have on the rest of the traffic analysis?
It would increase the traffic impact at the impacted intersections by approximately 30%.
Okay. I have just one more question about discounts before we can move on to another subject. And by the way, everyone, we are already about, perhaps 2/3 of the way through the rebuttal here. So we're moving right along. But I want to just explore one more discount that they took here. So I'm going to take us back to Appendix F. It's always hard for me to tell what I'm seeing versus what you're seeing. Mr. Norris, are we looking at Appendix F, that same table we've been looking at?
Page 815, yes.
Yeah, okay, fantastic. So far, we've been talking about this pass-by discount of 1,513 trips. I see there is another discount that they've taken for the so-called shopping center. It says internal. Do you see that as well?
Yes, I do.
How many internal trips are they taking as a discount?
For planning area 1, they're deducting 268 trips.
What are these internal trips that they're discounting?
Internal trips, as we've discussed here, are the trips that interact between the various land uses on the site. So they would not be trips that would be accessing the adjacent road network, but it would be all internal to the development.
Is there anything wrong from a traffic modeling perspective in taking discounts for internal trips?
Well, the thing that's wrong about it is it's very limited data available to support the use of that number. In fact, again, going back to the ITE trip generation handbook, it states the analyst is encouraged to exercise caution in applying the data presented because of the limited sample size and scope. Additional data should be collected where possible. Caution, the estimated typical internal capture rates presented in the table rely directly on data collected at a limited number of multi-use sites in Florida.
I see. And do you think that a limited number of multi-use sites in Florida have much to teach us about this particular site in Snoqualmie?
Without local verification, I would not accept it, no.
And has there been local verification to the best of your knowledge?
I think the city used their MXD model as some of a basis for verifying it, but it's really based on the same thing that the ITE analysis was, and they basically supported 10W's use of the internal rates that were generated by ITE.
What would you have done differently with regards to internal trips?
Again, I think going back to the use of and in respect of Mr. Sturbank's comments, the Snoqualmie adjusted PSRC model and use of the characteristics of the internal trips in that model, where they define, like I said, these various trip purposes, including home base work, home base shopping, home base recreational, non-home base, all those trip characteristics and categories are broken out so that you can figure out what kind of internal trips exist within a particular zone.
All right, thank you, Mr. Norris. I'm going to move on to a new subject here, which is analyzing traffic on weekdays versus weekends. Do you agree, Mr. Norris, with what I think I heard Mr. Schramm said, which is that there was no LOS analysis done for weekend trips?
Yes, I agree with that.
Okay. Do you believe that weekend trips generated by this project will be lower, higher, or about the same than weekday trips?
Well, Mr. Schramm in his calculations demonstrated for planning area 1, that the weekend trips, Saturday trips, were actually a little bit higher than what the weekday trips were.
Let me pause you there. We'll go to the DEIS. Yeah, all right. I'm going to take us to page 390 of the draft EIS. All right. Does it say on the top of your screen here, exhibit 3.11 TAC 14?
Yes, it does.
All right, very good. Is this the source for your testimony just now that at least Saturday trips will be slightly higher than weekday trips?
Yes.
Where are you getting that exactly?
Well, in that exhibit, the first row entitled Weekday Daily shows a total trips of 5,768, and then compare that to the Saturday Daily of 5,780.
All right. Stop there. Well, I stopped that screen share a little too soon. Mr. Norris, do you think the weekend numbers accurately reflect the traffic that will be associated with this project?
No, I do not.
Why not?
Because the DEIS itself said that tourism traffic were not quantified in this analysis.
I've highlighted that very sentence. We're on page 390 of the draft EIS. Everybody, that's right below the table we were just looking at. I closed my screen a little bit too early. Mr. Norris, what reason do you have for believing that tourism-related trips will be significant?
Well, I think this is a recreational area. There's major recreational opportunities there, and we've got Snoqualmie Falls adjacent. So I expect there'll be a number of trips that will be coming to this site. I know there's some discussion about a wine oriented uses. So
could the event center space be a contributing factor to tourism-related trips?
Most definitely. I know there was originally a discussion about an amphitheater concept there that would potentially draw traffic, significant volumes of traffic on the weekends. So there was no discussion of those kinds of things in this analysis.
Would you say that tourism trips are more likely or less likely during the weekend?
I'd say they're more likely during the weekend.
So what does the failure to consider weekend tourism trips have on the city's ability to understand the traffic impacts of this project?
It's reducing the level of impact of the traffic generated for this site.
My question was, I understand that it makes the numbers lower, but what effect does that have on the city's ability to understand the project's impacts?
The resultant increase in traffic volumes will have a direct impact on the capacity of the intersections to handle the development traffic during the weekend time period.
And has the city been made aware of these numbers?
I didn't hear your question.
I said, I think we may be getting a little bit off track, but I'll withdraw the question. I think we're ready to move on to another topic. Were you present for the testimony of Mr. Schramm regarding has he ever been asked to redo a traffic count on the grounds that his traffic count is too old?
Yes.
And have you ever been asked to redo a traffic count on the grounds that your traffic count is too old?
Yes, I have.
Who asked you to do that?
King County.
How old was your traffic count?
About 1 year.
You saying you had a 1-year-old traffic count and that was too old?
That was too. It was a little bit over a year. Yeah, and they said it was too old.
Who is they?
The King County transportation planning staff.
And was that a one-time thing or is that a regular policy or what?
It's a regular policy that they wouldn't accept traffic counts over a year.
Do you think that is a wise or unnecessary policy?
I think it's a wise policy to do that,
Why?
to accurately reflect the existing conditions, which all the analysis is built on the existing conditions. So if you don't have an accurate reflection of what's there right now, you're not going to have a complete understanding of what might be there in the future.
Do you see a under 1-year-old traffic count as a necessary tool for analysis or merely a nice to have?
I think in all these things there, and particularly through this document, there's been a just cutting the corners on a lot of this analysis that's normally done. And I think the not having recent traffic counts is part of that analysis and the cutback on the actual impact of the project.
All right, my final question has to do with the interchange between SR 18 and I-90. Were you present for Mr. Schramm's testimony about the interim improvements to that interchange?
I was present for both Mr. Schramm's testimony and Mr. Breland's testimony regarding the improvements that were made and whether or not they improved the level of service at this intersection.
Well, can you describe for us the situation before the improvements, the situation now during the interim improvements, and the supposed future situation once all improvements have been made? Just give us that whole timeline, if you would.
Yeah. So initially, there was the intersection of the westbound I-90 off-ramp and on-ramp. And then we had Snoqualmie Parkway to the north and SR 18 to the south. The way it operated was there was one through lane for southbound traffic on Snoqualmie Parkway and one southbound right turn lane onto the westbound I-90 on-ramps. In addition to that, there was a northbound left turn from SR 18 to the westbound on-ramp and two through lanes, northbound through lanes on SR 18 to Snoqualmie Parkway. That was the original configuration. And the southbound right turn lane used to experience extensive backups on Snoqualmie Parkway well beyond the 99th intersection, which is the access to the hospital.
Okay.
As a part of their improvements, WashDOT constructed a protected lane between the northbound left turn from SR 18 and the southbound right turn from Snoqualmie Parkway.
Is this the interim improvement you're talking about? Right?
This is the interim improvement.
Okay.
And part of that analysis, they also installed ramp metering on the on-ramps, the westbound on-ramps. What that in effect accomplished was it extended the length of the queue pocket from just being limited to Snoqualmie Parkway to the on-ramp to westbound I-90.
Wait a moment,
And
Mr.
also,
are you saying that the interim improvements have now caused traffic to back all the way up the on-ramp?
yes.
Okay.
Yeah. In a sense, all the improvement did was move the location of the queue because the traffic now was controlled rather than by the signal at the SR 18 westbound on-ramps. It was now metered through signal installation at the head of the ramp. Gotcha. So instead, you just move the queue further up the ramp is what happened. It was no visible improvement. And I can say this as one who regularly traveled up to the Starbucks in the morning for coffee and had to pass through this and observe this. So virtually there was no improvement to a level service or intersection operation other than you could indicate that it moved the queue off of Snoqualmie Parkway and off of the northbound left turn lane onto the on-ramp.
All right, got it. But this is an interim situation. So what's the final configuration supposed to look like?
The final is a total redo of the interchange into a urban diamond interchange that will improve the capacity to all these different ramps.
Do you believe that the final design will have the effect of improving capacity?
Yes, I do.
Okay. Now, how does this interim versus final configuration play into the traffic analysis that appears in the EIS?
Well, I think the first thing is the analysis failed to evaluate the impact of the proposed improvements, either in the interim condition or in the ultimate condition. So we really don't know what how the interchange is going to be impacted by traffic generated by the mill pond. So I would think that that would be one thing that would be part of a informed decision about the impact of the improvements. There was no mention in the EIS that the consultant had conferred with WashDOT about potential traffic generation from the mill pond and whether or not that was considered in the design of the I-90 interchange.
You mean the final design that they're working
Final
on?
design, yes.
Okay. All right. Thank you, Mr. Norris. No further questions. Oh, wait, I'm getting a call here.
Okay, hi. Thank you, Mr. Norris. We'll do cross-examination from the parties. Is that right, Mr. Sados? You're done?
Yes, I just thought it might be someone calling me with some brilliant questions to ask Mr. Norris, but that's not the case. So I think we're ready for cross.
Great. Mr. Cartman.
Good afternoon, Mr. Norris.
Good afternoon.
I think I just have a couple of questions for you. Going back, hopefully very briefly, to the pass-by trips issue. I don't think I need to pull up the diagram that we've all seen many times. There was discussion about 1,513 pass-by trips. Is that right?
Correct.
And did you understand Mr. Schramm to be saying that all of those trips would be coming from Mill Pond Road?
No, I did not understand to say that. I understood that he was saying that trips were coming from SR 202.
Okay. And did you hear Mr. Schramm say that he considered those trips to be going through the intersection and that he considered those trips in his intersection analysis?
Mr. Schramm was misleading because the past trips, he was deducting them from the traffic generated by the site. And those aren't technically pass-by trips that he was relating. If they're coming from 202, they're not pass-by trips.
Okay, is your testimony that Mr. Schramm was misleading the hearing examiner regarding whether those trips were figured into his analysis of traffic at the SR 202 Mill Pond Road intersection?
Yes.
Thank you, no further questions.
Okay, then do we have questions for this witness from the city?
Yes, I do, Ms. Examiner, and I will try to be brief. Good afternoon, Mr. Norris.
Good morning or afternoon, Mr. Sturvey.
You may have said this before, but when you refer to the ITE trip generation manual, is that part of what represents the state of transportation engineering practice?
That is one aspect, yes.
Okay, and the manual itself provides for understanding a difference of opinion, I think, between the experts who testified about what to call them. But the manual provides for internal trip capture, pass-by, and divergent link trip reductions, does it not?
Not out of hand, no, it doesn't. There's a special calculation that is offered in the handbook to represent that, expressed to be used with caution.
I'm not asking you to characterize it. I'm just asking, the manual itself provides for those type of trip reductions in a traffic impact analysis, does it not?
The handbook does, not the manual itself.
All right, and is the handbook part of the state, what represents the state of transportation engineering practice?
When you're implying it represents the state, it's a tool. I wouldn't call it the state.
No, I don't mean the state as in the state of Washington. I mean, it is part of the standard or the state of practice that a professional transportation engineer would apply.
I wouldn't call it that, no.
Oh, I see. And are you saying that you've never taken an internal trip capture reduction for any project that you've ever analyzed?
Nope, didn't say that.
Oh, so you have.
Yes, I have.
And you have included pass by trip and divergent trip, link trip reductions as well?
Yes, I have.
Okay, thank you. Now, with respect to the mill site project, do you think the traffic impacts of planning area 1 would be larger or smaller than the impacts of planning area 2 and 3 combined?
I believe their planning area 2 and 3 are more extensive trip generation.
Okay. And in fact, more extensive than even your difference of trip opinion with Mr. Schramm's analysis.
I don't understand your question. What are you talking about differences of trip?
Well, you just spent some time with Mr. Seidels critiquing the trip generation and the trip reductions taken with respect to planning area 1, correct?
Yes, that's what we focused on.
Okay, and so there's you have a difference of opinion in terms of the number of the trip generation that should be assigned to planning area 1 as opposed to what Mr. Schramm did, correct?
That's correct.
And the total traffic impacts planning area 2 and 3 significantly exceed the difference of your opinion and Mr. Schramm's as to planning area 1, correct?
Correct, but they took the same deductions in those categories too.
I understand that, but even so, the impact is significantly greater than what you're arguing about with Mr. Schramm for planning area 1.
Well, it's just the extensive growth of the site plan.
Now, when you're talking about the interchange improvements, are you suggesting that the FEIS needed to wait until the full interchange was built and then analyzed?
I think that Mr. Schramm acknowledged he knew what the several different alternatives for the interchange were. And I don't know that it would be abnormal. And part of the normal processes I would do would look at the impact of each of those alternatives on the proposed action. In my past transportation planning work, I've done that.
You would have analyzed, even though the specific alternative's been selective and is moving to construction.
It didn't hit construction. What are you saying?
No, it's moving to construction. It is about to start construction, correct?
Right.
And you're suggesting that Mr. Schramm should have gone back and analyzed each of the alternatives, essentially redone WashDOT's alternative analysis?
Mr. Schramm indicated he knew what the alternatives were. I think that you should evaluate what is the impact on the interchange of the proposed action. And I think that would be of value to the city to know what kind of changes should possibly be made or incorporated into WashDOT's design to help accommodate this development. That would just be a normal part of transportation planning activity. And I would think the city would want to know that.
And you don't have any information about the extent to which the city already did coordinate with WashDOT on the design alternatives, do you?
I know there was some coordination. I attended some workshops and things, but I'm not aware of anything that Mr. Schramm or this applicant did in terms of coordinating with WashDOT on what the implications of the project were.
You were just saying you thought the city should be coordinating with WashDOT. And so are you aware that the city did or did not coordinate?
I'm aware of the city, that the city did coordinate. I don't know what extent they coordinated, and I don't know whether they coordinated the aspects of this trip that or this project that might be benefited by understanding what the issues are,
Okay.
which would be part of a normal traffic study for a situation like this.
All right, thank you. I have no further questions, Ms. Examiner.
Thank you. Mr. Seidels, is there any brief redirect?
No, thank you, Madam Examiner. Sorry about
Thank
my
you.
video, but
No,
but
it's fine. It's fine. Mr. Norris, thank you so much for coming back today and for your testimony in this matter.
Thank you very much.
Appreciate it. So, next order of business is next rebuttal witness. Could we have a heads up? Remind me who that's going to be. I don't think we had the order established. Somebody from the appellant team.
One moment. I think there's some.
I'm unmuting, sorry, and
It happens.
making myself visible.
It happens.
Right. Here we go. I think we'll call Mr. Drodowski next.
Great.
Might need to be elevated.
May I just check in? Mr. Brooklyn, I think you were in your other hearing probably during this discussion.
Right.
But at the outset of after lunch, we had inquired about our prior request to have Ms. Jenkins move forward, and I believe Ms. Clinton indicated that Mr. Drodowski was going to go last so that Ms. Jenkins could move forward.
We're going to get them all done today. We're aware of that. It actually was more convenient for other purposes to get Mr. Drodowski on now. So, but we're very mindful of getting Ms. Jenkins on.
Okay, and it's just that the end time for applicant's witness is 5 p.m. So we need to complete Ms. Jenkins' rebuttal by 5.
We will be zippy.
And
Did you hear that, Mr. Drodowski? You got 2 witnesses behind you.
Ms. Carey?
Put me in, coach.
Okay.
yes, I think we've already covered this, but both Ms. Cook or Dr. Cook
Yes.
and Ms. Jenkins, to the extent they're testifying on contamination issues before 5.
Yes. Okay. Thank you.
And hopefully leaving a small amount of time for the applicant and city's rebuttal. So possible.
Well,
Understanding.
I don't want to use up our time debating that, but I
Absolutely.
think we have the burden of proof. I think we go last. So.
Okay.
I don't want to waste time on that either. I'll let you go ahead with your witness.
All right.
Yeah. So I just want to remind Mr. Drodowski, you do remain under oath to tell the truth. Please go ahead, Mr. Bricklin.
Thank you. So, Mr. Drodowski, I think we maybe just have three issues to address. One is, first one I want to address is the Shoreline Master Program, addressed by Mr. Johnson, I believe another witness as well. And just to kind of move through this as quickly as possible, it's the Shoreline Master Program has recently been amended by the city of Snoqualmie, right?
Yes, that's correct.
And have you reviewed it to determine whether these were minor changes or more significant changes that were made?
Yes, my earlier testimony was that the EIS should have done a side-by-side comparison where you take the shoreline master plan, you compare it against the land uses, and you see the regulations, and you see if there's congruity. The applicant argued that they did that, and so I didn't recall that. So I went to the DEIS, and the DEIS says this. It says the updated SMP was adopted in August of 2019 and was submitted to the Department of Ecology for review, and agency comments have not been received as of this writing and will be addressed in the final EIS as appropriate. So,
And do you happen to have a page number for that in the draft?
It's under Shoreline Substantial Development Permit. I'm sorry, it's under the Shoreline Master Program.
Okay, that's fine.
So in effect, what it says that we're working off of the DEIS used the old, and they said the FEIS will address any changes. So then I went to the FEIS, and here's what the FEIS said. The FEIS said, Section 5, the city adopted the ordinance on August 26, 2019. Ordinance that was substantially the same as the draft SMP that is the basis for the consistency analysis in the draft EIS. So The city conveyed its acceptance of ecology's changes by letter on August 10, 2021, and it is substantially the same. So what I did is
Substantially the same as the draft master program, not substantially the same as what was analyzed in the EIS.
No,
Right.
what it said was, it said, so in other words, the city's EIS, the FEIS and the draft EIS goes like this. The draft says there's an update coming. The FEIS says we already did the analysis. There's no substantial changes, particularly with respect to land uses, but there's no substantial changes. So what I did is I went back in and I studied the document. It's 300 pages, the whole staff report. And it's and what I keyed in on was the correspondence from the Department of Ecology. The Department of Ecology, in their conditional approval, they said that you have to, the city has to accept certain required changes, and they recommend that the city should accept certain recommended changes.
Madam Examiner, objection.
Grounds?
Relevance outside the scope of rebuttal. Compliance with the Shoreline Master Program, comprehensive plan are not appeal issues. I'm not sure where this is going.
So we addressed this during the Mr. Derdowski's first testimony, and this was being argued under the heading of land use. So I'm going to allow it, although I hope it will come to an point.
We are almost at the end.
Okay.
Yep. So what I did is I compared the, I took the Department of Ecology's required and recommended changes, which were all included in the ordinance that the city adopted. And I analyzed them to see what was there. Many of them were the same, but there are some significant changes. And one of the more important ones that I found was this. First of all, there's a requirement that there has to be a report from a professional archaeologist to investigate the cultural resources. But more importantly, from a land use standpoint, which is what I'm discussing, is that there was additional language that went like this. In the event of a conflict between the map and the environmental descriptions, the narrative environmental description shall control. That's in condition 8. And what that means is that when the city describes the natural environment and provides a map, and that map is what went into the plan, right? That in the event, ecology is saying that in the event, if there's a disagreement between the narrative of description and the map, the narrative should govern. So then the Department of Ecology required that there be a new narrative for the natural environment. And it described the east-north bank of the Snoqualmie River and described where that is. And I believe that if you take the description in the updated Shoreline Management Act plan, and if you compare it to the plan, that I think you'll find an inconsistency. And that's important because another change the Department of Ecology required was a 200-foot setback from the river as opposed to 100-foot. And so what that means is this. And again, I did not do a really detailed map analysis, but this is only one change that I saw. I saw some other changes. And the reason I'm testifying in this manner is that my original testimony was there should have been a side-by-side. City said, we did a comparison. It is clear to me that they did not do a proper comparison. They characterized the changes as not substantial. And I believe that a very tight analysis, which might be done by the hearing examiner, I would think, to compare those two would be able to determine for sure that there's no substantial difference. And I believe that the possibility that the narrative conflicts with the map, which would result in a 200-foot setback for certain areas, is a very substantial difference. I cannot say for sure that there is a difference between the map and the narrative, but the Department of Ecology added the language, narrative governs. They added the language 200-foot buffer. And there are approximately 5 pages of required changes and about three pages of recommended changes, all of which was accepted by the city council in August of 2019. That's my testimony on shorelines.
Thank you. Let's go on to population and pipeline projects.
Yes.
That was addressed by Mr. Rogers today, and I believe Mr. Johnson and others earlier. I know your earlier testimony was that the EIS inaccurately analyzed this issue, and the respondents' testimony was no, it was all done correctly. What is your response to that testimony from the respondents?
Well, I based my testimony on some analysis. I was concerned that the city planner, in response to what I said, and I believe there was another person who testified that the background traffic, or background growth, that the growth in the pipeline was negligible, the future growth was negligible, and the staff and the applicant, as I understood it, relied on a memo from Chandler Felt, an old friend of mine he's been retired, who was the county's demographer, who 4 years ago, before COVID, made a comment that there wasn't going to be any growth out here. And they relied on that to argue against what I had put forward. Well, here are the facts. According to the very latest growth capacity report from April, last year, the city has existing capacity for 168 units on 14.5 acres for housing. They have in the pipeline 204 units in the pipeline already, working through. That was as of spring of last year. That's a total of 372 units. Now, the new growth forecast that the staff it's just been let in as an exhibit has a forecast of 1,500 units. That means that the difference between so the city has capacity of 372 units of housing currently. This proposal is only going to add 160, and part of those 160 are included in this projection. The forecast is for 1,500. So roughly, 1,200 units of housing. They don't have, where are they going to put it? They have a 1,500 forecast. They have 372 capacity, and you know where it's going to come from? It's going to come probably, in my opinion, from annexations. And in fact, there's some data for this.
Well, hold on, but before you get into that, in terms of the EIS analysis of land use impacts, does the EIS acknowledge that by devoting the subject property primarily to non-residential uses, that is going to create a problem in terms of residential land use capacity downstream? Oh, no, not at all. The concern is that when you this project will create 20 times more jobs than houses. 20 times more jobs than houses. And what that means is that those jobs are going to be filled by people that are probably going to commute. And the city doesn't have additional capacity within its borders to handle that housing need. And did the EIS address that? Not a bit. And that's a very, when we talked about compatibility analysis and impacts on the surrounding area, where we talked about cumulative impact, certainly the idea of building a major employment center when a city only has a very tiny capacity for housing. So that the city responds to that and says, well, there's not going to be much growth. Well, they're putting an employment center, and those people are going to require housing. So they can't have it both ways. If they're going to bring in those jobs, those people are going to commute. They're going to have to find a place to live. There's no affordable housing out in that area. We all know that. And so that is an environmental impact that should have been looked at. But then on the other hand, the city says, well, there's not going to be hardly any growth out here. But nonetheless, just 3 years ago, they almost approved, they turned down an annexation for 1,100 units of housing and commercial south of Snoqualmie Ridge. That's the place you ought to put growth, south of the ridge. That is logical. It's contiguous with. Well, Mr. Drudowski, let's not be getting into policy discussions. I want to focus on the adequacy of the EIS. Yes. So, and I think you've covered that. Yes. And I think that might be That's all I had on my list, but I think there may have been one more on yours, but
Yes.
maybe not.
Yeah, there is one other. There was some confusion that was cited by folks about the development agreement and what the comments that I made about the development agreement. And this is an important thing, and I'll bring attention of the hearing examiner to this. RCW 3670B 170 describes what development agreements do, and that's breathtaking, really. And I won't quote it all, but among other things, development agreements can do the following. They can establish mitigation measures, development conditions, and other requirements under Chapter 43.21, which is the environmental issues.
Objection.
Grounds.
It sounds like Mr. Dudowski is about to offer his legal interpretation.
He's
of the
not.
statute.
He's
No.
not. Please give him a chance, counsel.
So
I'm sorry,
so-
since I didn't hear a question, I have to interpose the objection. I will stop, but I thank you, Ms. Examiner, for the opportunity to make my objection for the.
It's noted. Thank you.
I perhaps was not as clear about my concern about the relationship between development agreements and SEPA. And it was partly because I was interrupted. And subsequent to that, I think the city testified that, well, I think Mr. Wyman said, I was lost. I didn't understand that. And what I'm attempting to do is to make crystal clear what my concern is. My concern is that development agreements are very, very powerful. And the RCW 36 gives it a lot of power. If you go to the Department of Ecology website, they say, quote, if the final approved proposal falls within the range of alternatives analyzed in the EIS and all likely significant adverse impacts have been evaluated, additional review would not be required. So here's what the concern is. The development agreement, which is ill-defined, there's no process, there's one public hearing according to state law, but these are negotiated between, they're contracts, they're negotiated. The law allows them to cover mitigations, conditions, wide, just breathtaking range of issues. Those issues should be informed by SEPA. The response we had is that, well, we might consider, the EIS says, it will consider future SEPA review. But this SEPA review is so broad that the city is easily going to be able to say that we considered the full range of alternatives here, so we don't really have to do anything. They might not even do SEPA. I did a search on how many development agreements have issued SEPA determinations that went to the Department of Ecology.
Objection, speculation.
All right.
No, he's citing data.
Yes, there is.
Noted.
It is uncertain. It is not at all clear that the impacts are going to be, the environmental impacts are going to be considered on aspects that have not been well defined in phase, particularly phases 2 and 3. So
Noted.
that's the concern I have.
And we're done.
Okay, thank you. That's it.
All right. Thank you very much.
Hey, thank you.
So I think I need to find out if there's cross-examination at this point from the city and from the applicant. City?
I just wanted some clarification for the record about the pages of the EIS or draft EIS that Mr. Dudowski was addressing in the very beginning related to shoreline use.
Yeah.
Can you
And
direct me, please, Mr. Dudowski,
Sure will.
to the pages?
Sure,
that-
Mr. Trevor. Hang on just a minute. I closed those files, and so let me find them.
And were you in the final or the draft? I guess that's the first question.
I considered, but oh, I know, here they are. I can find it easier through this. Let me, it'll just give me 60 seconds here. And here we go. Okay. Okay. I quoted a section of the DEIS.
Sorry,
Where, the pages, something, Mr.
no,
Sherman?
I'm sorry, I couldn't hear you, Mr. Dudowski.
Oh, sure. Okay. The
Did you say
FEIS
draft?
section,
Draft environmental impact statement?
yeah, I quoted from both. I have the citation for the FEIS, and it is section 3.7.5, page 3-186. And that's where it says that it says draft EIS section evaluates the proposal's consistency with SMP shoreline government environmental designations. The
Okay,
citation I
we're-
gave was a little bit after that section.
Okay, we just need
And
the
then
page numbers at this point.
In other words, if you just, hey, there's not much.
Mr. Dudowski,
Yeah.
Mr. Dudowski, we just need page numbers.
Just the page numbers.
Don't have, if you give me some time, I can get them for you.
Yeah, why don't we go to the next witness, and in between the following two witnesses, Mr. Dudowski will provide the page numbers.
Mr.
And by the
Sturbank,
way-
was that your
My-
only question, Mr. Sturbank?
That's fine. Mr.
Okay.
Brickland's proposal is fine.
Okay, well, let me
If-
find
if
out
I was
first.
speaking- If I was speaking rapidly, it was to accommodate your time.
Understood.
Just need page numbers.
All right, I'll go get them.
1 second, let me find out, does the applicant have cross-examination questions for you?
We do not. Thank
Okay,
you.
great. So Mr. Durdowski, if you could please find the pages that you're citing for that shoreline discussion, that would be great.
Okay.
Thank
And
you.
actually, if for purposes of expediency, if Mr. Brickland would just like to forward those to the parties, we can.
Sure.
move on to the
Mr.
other-
Dudowski, you can just email me the page numbers and I'll forward it to the others.
Okay, you're on.
That
Thank
would
Okay,
be
good
good.
luck. Bye-bye.
Thank you,
you
Mr.
very much.
Sturbank. Good
Thank you,
idea.
Mr.
Thanks very
Brickland.
much.
Bye-bye.
All right. Next, rebuttal witness from the appellants, please.
I think Ms. Clungen's going to take the wheel.
Yes,
Okay.
thank you. All right, we will have Dr. Cook next.
Great. Just waiting for Dr. Cook to get to the place where she can share her video so we can.
I believe I've already, oh, here we go. Sorry, second click. Okay, there we go.
Excellent. Thank you very much. Just want to remind you, Dr. Cook, you remain under oath to tell the truth. And
Yes.
Great. Ms. Clungen, please go ahead.
All right, good afternoon, Dr. Cook. All right, let's just dive in here. Maybe we'll see if we can finish up before 5 today. So let's start with, we're going to start with the wetland delineation. So Mr. Wright testified that he disagreed with your characterization that the wetland delineation was in any way out of date or missing information. What is your response, and why is the timeliness of the wetland delineation important to the decision maker's analysis?
Yes, regardless of whether the sunset was in March or May, it's very clear that at some time during this half of the year, the delineation is going to be out of date. And the reason this is important is that wetlands are not static systems and they change. And the bulk of this work was done 10 years ago, back in April, May, and June of 2012. And the updates were done in 2014 through 2017, which is 5 years ago. And that's a pretty long time for a wetland to remain static, especially on a site where there's all kinds of ongoing activities. Especially in light of the fact that they're proposing so much grading in the area of the buffer surrounding the wetlands. The lower part of 12, the entirety of 28, and the entirety of 29, the wetlands 28 and 29. So I need to be sure that just saying that we're going to do this where there was no evidence of that in the final EIS is not really making the citizens group feel very secure that this is going to happen. So as I stated earlier, this needs to be a condition of approval in both the EIS and the permits to be sure that this is done, because otherwise we can't be sure that the wetlands are the same size that they were back in 2012. And I would also add that there was no data that for either the redelineation of wetlands 12, 28, and 29, and any of the directly adjacent wetlands There are only data sheets. There's only a data sheet for ditch 19 in the addendum to the DEIS, and the Corps only actually talked about looking at wetland 19 and 29 with respect, or 25 with respect to verifying whether or not they were wetlands, and it was determined that they weren't wetlands. And they went to the trouble of including the data for 3 areas that are no longer considered wetlands, but they didn't include the data for the wetlands that even in phase 1 that updated the delineation. So we really don't have a handle. I mean, for EISs aren't just for the public, they're for the agency people who are reviewing an EIS to determine if in fact there's going to be environmental impacts as a result of the proposed development. And if you don't include the data, the agency staff who have knowledge of these things can't make an informed decision. So that needs to be done.
Okay, and when you say the data, I mean, in the, I believe, Appendix C of the draft EIS, there are classifications and things like that, but what data in particular would be important to have here?
The delineation data sheets, and with respect to establishing buffers, the rating sheets. There is a table in the DEIS that states that ratings were redone using the 2014 methodology, but there are no data sheets to confirm that this was actually done. And there is no way for the agency staff to determine if the data sheets were completed correctly for the re-rating. So this is, it's just not in the record. So it's not available.
Okay. And in your opinion, what other information is missing from the record to analyze the wetland impacts?
As I said, the Appendix C tables, which was on page 106 of the PDF, it gives the data, indicates that there were updates done, but there are no attached data sheets for any of that. So it's standard in our business that no matter when you generate a delineation report, even if you're updating and adding an addendum to an original wetland report, that all of these delineation data sheets and rating forms are included. And I just find it really odd that none of that data was included, which is why I stated that it hadn't been updated. So I've been working in this business as a reviewer for multiple jurisdictions, small and large, and done projects myself in my capacity of being a wetland ecologist and doing delineations, and it's always required. So it seems odd to me that this data wasn't included. And Mr. Wright said that the data was included for the Army Corps of Engineers, but in the letter that is also in the addendum in Appendix C, they weren't attached there either. So if they were supplied, I find it odd that the Corps didn't include them either. So the city needs to make an informed decision. The city's third-party reviewers need them to make an informed decision. And the other agencies who have capacity for reviewing the EIS also need them to make an informed decision, and the data simply isn't there. And so this would be for wetlands 12, 28, 29, ditches 2N, 7, 9N, and 30. Those are all on the phase 1 property. And then with respect to being sure that the project isn't going to impact just adjacent wetlands, it would also have to include all those wetlands that are just adjacent to the property.
Okay, thank you. And all right, moving on. Mr. Wright testified that he considered, but was not directly involved in the hydrologic modeling and assessment. In your experience, what's the benefit of having engineers coordinate with their biologists, ecologists in the wetland assessment?
I've been working in the field since the early 1980s, and I find it common that engineers do biologist work and assume that biologists don't know anything, but it actually is the opposite case. Engineers know very little about ecology and biology, and they shouldn't be doing these models without input from an ecology. This includes designs for the 3 treatment wetlands that are included in the stormwater design. And these are that would be figure 6-1 and page 102 of the PDF.
Hold on. 1 sec. Figure 6-2 of the PDF.
6-1 on page 102.
102, is that of Appendix C of the draft
Yes,
EIS?
that's Appendix C of the draft, addendum to the draft EIS.
And I'm sorry, you guys were both speaking. So Ms. Clinton, could you please give us that whole citation?
Yes, so it is the draft EIS Appendix C. It is PDF page 102, but it's labeled as figure 6-1.
Thank you so much.
Because the engineers don't understand the difference in habitat types in the hydrologic models that they're using. It classifies forested conditions, shrub conditions, grasslands, and they don't understand that wetlands typically have zones of each of those incorporated. And so you need to understand the current conditions, and you need to understand the conditions post-development. And there's modifications you can make in the model that alter the numbers of what gets plugged into that model that can really alter the results of the outcome of how the modeling is done. And with respect to soils, they're using the Soil Conservation Services maps for a site, and those are notoriously incorrect. And so they need to be using the on-the-site soils characterization for a particular wetland. And those can vary tremendously from what the Soil Conservation Services maps use. And they're plugging in a data value in the model based on the mapping from the SCS and not what the on-the-ground conditions are. And so again, that's another area where your model can be highly inaccurate. And if you have the wetlands person who's been out on site and done the field work, they can tweak the model and say, no, you're using the wrong values in this part of the model. You need to update that. So this is just 2 examples. And there is also a misunderstanding by the engineers on what the important parts are of the model to tweak with respect to wetlands. If you're modeling a stormwater area for stormwater design, that's different than modeling what we call a hydrograph, or the hydrologic regime across the year for a wetland. And mostly we're interested in the shallow part of the soil that's called the rooting zone, because that's what's ecologically important to the plants and therefore the animals. And typically the geotech firm and the engineers, et cetera, geohydrologists are doing really deep borings, and they're kind of throwing the data away for the top 1 to 2 feet, which is actually the area that is ecologically important for us.
Ms. Examiner, I'm going to object again on the grounds of speculation. There's absolutely no evidence in the record that anybody on our team threw away data. So, and nor any evidence that, at any rate, I'm just going to object on the grounds of speculation. Apologies for taking too long.
Thank you. I'm noting the objection, and we'll allow Ms. Killer to deal with it on cross. Please go ahead.
So when you look at the log borings, which are in, I believe they're in the AESI report from 2021, which is Appendix B in the FEIS, you can see that there's almost no data for that top 1 to 2 feet, the borings, of the 9 borings that were done, none of which were done in the wetlands themselves. That data isn't even included. So I stick with my statement that they didn't include that in their assessment and tweaking the model. because
In your
it
experience,
wasn't
in your
available.
experience, is it practice to have borings in the wetlands?
It's very common to have something called a shallow groundwater well, also called a piezometer, where you go down a few feet and stick in a gauge, either a continuous gauge or a PVC tube that is filled with cork dust. So as any groundwater changes, you can measure what those changes have been. And at the time when you're installing those piezometer wells, you take boring samples and you map the stratigraphy of that area. So yes, it is common to do that, and that was not done in this project.
Okay.
So let's see if I've covered everything. And one of the things that I wanted to mention is that, you know, an ecologist will notice microtopographic differences within a wetland. Typically the models are looking at 1 foot elevation changes, and plants react to 3 to 6 inch changes in hydrology. And you can have a completely different wetland community existing at those 3 to 6 inch increments. So if you've got a wetland that has lobes that have microtopographic changes, you can have a stormwater design that you're saying that your elevation of water in this wetland is going to be this, but if you've got a little divot that's not recorded because it's less than a foot in elevation change, all the water that comes in could go into that divot and flood that area, where the whole rest of the wetland could be left, you know, basically high and dry. And so modeling doesn't work on these large scale things. And that's precisely why you need the biologists to work with the people who are developing the hydrographs for these wetlands, because they've been on the ground and they know that, well, this little lobe has a deeper area, etc. So the modeling can be very inaccurate if you're not working with the biologist who understands these systems. And I understand this was just done, you know, to get a number. But again, one of the things that I want to point out is that it's very easy to forget later on during the development phase that this wasn't done to this detail, and to say, oh, well, we did the hydrologic modeling and it's sufficient, we don't have to revisit it. And that happens all the time. I've seen it both as a reviewer for different jurisdictions, and I've seen it when I've gone out to wetlands that are failing and trying to figure out why it failed when the modeling said it was going to work.
Okay. And then I also believe Mr. Wright testified that it was his opinion that there would be no impacts to the wetlands or the ditches in planning area 1. What is I believe you disagree with that, and why?
Well, I disagree with the blanket statement that he conclusively knows this, because they're proposing to excavate for floodwater storage in the area that is currently slated to be enhanced buffer and in the 3 created wetland ponds to the east and south of the site. And they have, and then they're going to be filling the plat itself for parking and buildings. So there's going to be compaction in that area, and there's going to be a considerable amount of fill if you look at the fill estimates and the grading plan. So to make that statement, I think, is very premature, especially since they haven't been recording pre-development hydrology in those wetlands. And again, they didn't sample for what the soil types were like in and around those wetlands. So I think their intent is to not have any impacts on the wetlands, but I don't think they've collected data to show that in fact there aren't going to be impacts. And with with the argument that we've already done groundwater monitoring, and that it fails to take into consideration that I'm talking about monitoring hydrology in the wetlands. So crest stage gauges in each wetland, and if there's multiple lobes in a wetland, having them in each of the sections of these lobes. It wouldn't apply to wetland 29 because it's too small, you'd only need one, but potentially for wetland 28, you could need more than one. And there's two sections of wetland 12, 12A and 12C, which are in the north, and then in the south part of the property. This needs to be done for all of those areas. And you need to monitor it for an entire year, a minimum of a year, in case you have an odd year hydrologically for precipitation and how the groundwater behaves. And without knowing that, the only way you're really going to track if the development is resulted in something deleterious is to watch the wetlands fail after the development occurs and then sit there and scratch your head and wonder why it's happened. So I think that Mr. Wright's statement is a little premature at this point. You know, I know his intent is that there will not be any impacts, but I don't think we can say conclusively because we haven't, there hasn't been the data collected pre-development to be able to say that they're going to be able to maintain that same hydrologic regime after they completely regrade the property, and the surface water drainage and the groundwater drainage is going to be completely different. Both are going to be different post-development.
Okay. All right. And then bouncing around a little bit away from Mr. Wright, but related to hydrologic modeling. So did you listen to Mr. Goldsmith's testimony?
Yes, it did.
Okay. And Mr. Goldsmith, this discussion of groundwater modeling, there was discussion of surface water and no consideration of groundwater was included in the modeling for the wetlands, and that it was discussion of surface water that perks.
And I'm going to object because that mischaracterizes Mr. Goldsmith's testimony.
Okay.
You actually didn't let her finish. So.
We'll get there. Thanks. So there was discussion of surface water as and rainwater as being one of the factors, I believe, in their modeling of the water on the site. Do you feel there's an issue with that approach, or you know, what is your concern about that method for assessing the hydrologic modeling?
I think that in a system where there is just a very deep aquifer and the only groundwater that you have within the rooting zone does come from surface water, it can be appropriate in those situations, but at least for wetland 28, well, at least for the wetlands on this property, because there is a shallow aquifer and because there is a lot going on in the groundwater that we don't have a handle with because the monitoring certainly just wasn't comprehensive enough. I don't think that was appropriate. And the groundwater component of these wetlands is not really known because again, there weren't these shallow groundwater wells within the wetlands to know whether or not that the modeling using the deeper aquifer and certainly using surface water is accurate. So I don't think that was appropriate. And to make the statement that they did use on the ground data when really the only thing that they had that was actual data was the precipitation is not accurate either. I mean, the placeholders they're using for the vegetation type part of the model is generic numbers for forested conditions, et cetera, not the actual veg that's on the ground and certainly not how the sites are going to mature post-development. So I don't think that was an accurate characterization.
Okay. And then did you have any other comments on the hydrologic modeling?
Yeah, again, he didn't use the biologists and ecologists to consult when doing the modeling. They just ran them and just assumed that their placeholder numbers were going to work, not understanding differences in microtopography and soils, etc., and vegetation. So, and that's where the biologists are really important in tweaking these models. And lastly, there wasn't any indication in any of the data that was provided that they did a back check and verified the accuracy of their model. And you can do that again by setting up gauges, inlet and outlet gauges, and that crest stage gauge weir within the wetland. So you can
you just clarify for me a back check? What do you mean?
Yeah,
by that?
you actually collect on the ground data to see what is actually happening on the ground, and then you model it, and then you see if the model is generating the same hydrologic regime that the actual data is generating, and that way you can test if your model is accurate. And that's what you have to do when you have to prove by both the King County Stormwater Manual and the state Stormwater Manual that you're not going to have excursions from pre-development conditions. And the only way to really check if the model that you've created is accurate is to collect on the ground data and back check if your on the ground data generates the same hydrologic regime that the model has generated. And they have, at least there's nowhere that I could find have they shown that that's the case. And they wouldn't be able to because they don't have any gauges in the wetlands themselves.
Okay. All right. And then heading over to some of the discussion of contamination as it relates to the wetland. Were you present for Mr. Schmidt's testimony?
Yes, I was.
Okay. So Mr. Schmidt discussed, a little bit more about the MACA process that would occur. And, I believe he said that it would need to happen prior to development, but it didn't have to happen before the EIS. What are some of the risks or consequences associated with that approach as it relates to wetlands?
With respect to wetlands, it's not consistent because they decided to phase the property, and then they've tasked ecology with evaluating MACA for the entire property, which could take years, of collecting data and waiting for ecology staff to do their review. So if they wanted this to be done quickly, they would have collected the data for just the phase that they're discussing, because I don't really see how that it's going to occur quickly if you're waiting for an entire site, especially since areas phases 2 and 3 do potentially have larger MACA problems. So, or there is more contamination in those areas. So I don't see how that's going to work. At least not in a timely manner.
Okay. And then he also discussed how he anticipated that various inspections would occur often, and that there would be a lot of oversight, and that they'll detect anything, and that the response would be relatively quick to the contamination that they do identify. Is that consistent with your experience?
No, it's not. I mean, I have even had my own projects that have gone south because there's two phases of the monitoring for contamination. And one is that it gets required, and two is and that there's staff to be sure that that requirement is followed through and that it happens. And two is that when the numbers come in for monitoring for contaminants or hydrology or whatever, that there's somebody to review the data so that if there is an issue, people identify it. So often, I can't tell you how many times I've seen both projects of my own and projects that I've reviewed, where it is a requirement as part of the best management practices to have monitoring of things like contamination and hydrologic regime. But then it never gets implemented, and there isn't anyone who checked that it didn't get implemented. And second is that, you know, I've seen projects fail, and you go out and you realize, oh, the data's been pouring in the last 2 years and nobody read it to show that, oh my God, there's, you know, this particular thing has happened. And I can give a quick example down in the city of Kent, where the old racetrack used to be. They constructed these wetlands and they failed miserably by the second year, and they had been collecting data on it and nobody bothered to look at it. And it turns out that the sediments they used had a pH of like 9, which is incredibly alkaline. And so they did monitor, but no one was reading, and it took the entire acres and acres of planted wetlands to absolutely, everything died before somebody bothered to look at the data and say, oh my goodness, I guess we should have looked at this. So this happens time and time again. So that's, you know, I disagree with him that there are people standing on the ground watching these things, you know, so we immediately know if there's contaminated sediment or something popping up in the water sampling, and we know immediately, because that's not how it works on these projects. It's just not. There's never the money, there's never the oversight. It just doesn't happen. So even when you place these as a condition of approval, it's still not followed through. So that's why it needs to happen at this stage of the game.
Okay. And have you been involved with wetland projects that also wetland projects that are involved contaminated sites?
Yes, I have.
Okay. And in those cases, I believe Mr. Schmidt testified it was common practice to include reports where there was a summary of the data, but not necessarily provide the data. In your experience, have you been a part of projects where you have seen, is that consistent with your experience?
No, it's not. It's not consistent. And this has been a failure of, I mean, I've even worked on been brought in on projects where summaries were included and data was not, and it was called out during a EIS appeal that and the data had to be provided. And one example.
Objection based on relevancy and speculation.
Noted. We'll just have her testimony and you can address it on cross.
Yes, Dr. Cook, do you recall the name of that project?
Yeah, it was called the B&I Pit, and it was up in Snoqualmie County. It was a mining company.
All right, thank you.
Yeah. So that's and then, you know, there's the Kent project I just referred to. I was brought in after everything failed to try to fix it. And so, yes, I've seen this happen. So it's not just, you know, it's not just a matter of it being a human health problem. I didn't hear anybody testify to the fact that they were worried that contaminants would get into the drinking water. My concern is that when these areas are opened up via grading to implement the grading plan and the flood storage plan, that it is within the floodplain, and we do have back-to-back rainwater events in Washington State with a fairly regular occurrence. And so if these areas are opened up and it turns out there are areas.
Objection to testimony regarding flooding and stormwater.
So I'm gonna let her talk about the reason why flooding and stormwater are concerns with regard to wetlands. That's something we did before. Go ahead, Dr.
That's where I'm going with this, is that if that occurs, then those contaminants can go in the surface water, and they will end up in both the on-site wetlands, the just adjacent off-site wetlands, and they could potentially end up in the Snoqualmie River and in Borscht Lake, where there are reported salmonids, and we could even have an issue of Endangered Species Act takings if there's a kill. So that's my
Object again. That was this is certainly beyond the scope of this is not rebuttal testimony. That particular item was new.
The EIS taking, or yeah, what the takings wasn't a taking wasn't mentioned before. It's true. She gave it as an example. We aren't going to talk about Endangered Species Act takings further, so we'll just move on.
Let's see, is there any other issues there? I think that answers that question.
Yes, I've gone through my questions here, but do you have any concluding thoughts or responses to the testimony as it relates to wetlands?
Yeah, there was just there was a statement that there was sufficient soil borings to sample potential contamination in phase 1, and that was given as a reason for why they didn't think that there was any reason to worry about contaminants. And I just wanted to point out, and again, this is with respect to the critical areas and the downstream receiving waters. The borings were done at a fairly deep depth, and nowhere in either the DEIS, the addendum to the DEIS, and the appendices and the FEIS and Appendix B, did anybody talk about where in those borings the sampling was done for contaminants, how deep it was? And I went through everything last night to try to figure out where this was occurring. And I don't think, because the fill depth was fairly deep, if they took those samples for contaminants too shallowly, then we're not going to know if there's contaminants lower down where they're going to be closer to the surface once.
And again, object calls for speculation.
Thank you. Noted.
Please
Go ahead,
continue.
Dr. Cook.
We're not going to know if there are contaminants in the areas in the critical surrounding the critical areas and the downstream receiving waters, should there be contaminants if they sampled it at an inappropriate elevation. So I wanted to bring that up because I haven't seen that addressed anywhere.
Okay. All right. Well, thank you very much. My questions.
All right, thank you. Cross-exam, I frankly, I can't remember who goes first, if it'll be the city or the applicant. Ms. Kaler?
I remember either specifically, but I have no questions for this witness.
Thanks for letting me know, Mr. Sturbank.
No questions from the city. Thank you.
All right. Dr. Cook, thank you very much for coming back. Appreciate your testimony in this matter.
Thanks for the opportunity.
Thanks, everyone. We have additional witness, I believe we're going to call Ms. Jenkins.
Yes, we are. But could I just request a brief break?
Can we do 5 or how about, yeah, 5, we'll do 5.
Okay.
We'll come back at 4:08.
Okay, all right.
Thanks very much. Ms. Clengen, please go ahead. Oh, let me remind you, Ms. Jenkins, that you remain under oath to tell the truth.
Roger that.
Thank you.
Hi, Ms. Jenkins. Good afternoon. Happy Friday.
Hallelujah.
All right. So were you present for Mr. Schmidt's testimony this afternoon?
Yes, I was.
Morning and afternoon?
Great.
Okay. So there were there were a number of discussions regarding what is involved in a comprehensive remedial investigation, which, if you remember, was, I believe I took direct language from the Department of Ecology's email for what they were requesting for the project. But can you explain what that might look like and whether that has been conducted on the site?
Sure. Let me just reiterate the MACA definition, which is not broad, but I mean, it's not detailed, but it says the purpose of a remedial investigation / feasibility study is to collect, develop, and evaluate sufficient information regarding a site to select a cleanup action under WAC 173, 340, 360 through 390. So it has a very specific endpoint to select a cleanup action. So I want us to keep that in mind. Another remedial investigation definition I found says an in-depth study designed to gather data needed to determine the nature and extent of contamination at a cleanup site, establish site cleanup criteria, identify preliminary alternatives for remedial action, and support technical and cost analyses of alternatives. That's actually part more of the feasibility study. So together, these two studies are usually referred to as an RIFS.
And Ms. Rice, no objection necessarily to the testimony, except it appears that Ms. Jenkins is reading off of something. And I'd just like to know if there's a specific definition or something that she's reading from.
Yes, there was. I'm sorry, I didn't memorize that definition. I'm glad you think that I might have the mental capacity right now to do that, but it's not true.
I was just curious the source for it. You provided the source for one definition, but not the second one.
I'm sorry. It actually came off a website that does insurance for this type of, that does insurance for property insurance that's going through cleanup.
Okay, thank you.
Okay.
Yeah, I'm sorry, I don't think it's still up on my computer. I would tell you which company it was, but that was the source.
Not necessary. Thank you very much for the clarification.
Sure. Let me see if I can get back on. There you are. Okay. So I think what I'd like to do is sort of paint the picture of what I believe a comprehensive remedial investigation might look like for this property. Okay. I think we can agree that the endpoint is cleanup. Okay. And so under the definition, we need to get enough information in hand so that the cleanup actions can be decided upon between the project proponents and their consultants and ecology. So there needs to be quite a lot of data collected about where contamination is, in what media, and how severe it is. Okay, that's basically what we're looking for. So we talk about the extent of contamination, which means lateral extent as well as depth. And it typically involves two media, soil and groundwater. It can include more than one groundwater aquifer or body of subsurface water. All right. And it was previously testified that there are two shallow, what you would call shallow groundwater aquifers at this site. One that's fairly near the surface of the soil, and then one that's a little bit deeper in the subsurface. Okay, so both of those bodies of water are potentially at risk from contaminants in the soil, okay, that have either happened because they seep down through the soil or they drip down beside building foundations.
An objection, just again, calling for speculation, just noting the objection for the record.
And speculation as to?
She is testifying that there's going to be a migration of contamination into shallow and deep groundwater, and there's no basis for that that's been asserted so far.
Thank you.
I'm sorry, I was just attempting to explain how contaminants might get into groundwater. I'm not saying they did. So forgive me if that, I'm just kind of painting a picture of how do we get the information needed for an RIFS. So the behavior of contaminants in the subsurface is something that people who do remedial investigations need to understand, because not all contaminants behave the same in the subsurface. So for this, sorry, four-legged family members that don't understand hearing protocol. Go on, lie down. I'm sorry.
It's okay. Go ahead.
Oh gosh. So let me segue over to planning area 1, because that's the simpler one to discuss. There has been, to our knowledge, a single investigation of that site, which was performed by Farallon and recorded in Appendix B of the final EIS. It has earlier been testified that there are no data tables or other, nothing but a general discussion of the findings from that investigation.
And I don't want to interrupt you, but just related to that, there was a discussion by Mr. Schmidt that was kind of standard practice, or at least in his experience, where he provided more of a summary without the data, and that was standard practice. Do you, in your opinion, do you agree with that, or in your experience, would the data normally be provided, or is this summary more standard?
Ecology will demand all of the data. And for this one very important reason, there are other reasons, but this one is extremely significant. Ecology is looking for, in these data, whether it's groundwater or soil, whether the existing contamination, if it's found, is above the MOTCA cleanup level that's been agreed upon for that site. Some contaminants have a very small number for that cleanup level, which means that the laboratory equipment that's being used to find these contaminants in the media have to have a quantitation limit sufficient to identify that concentration of contaminant is there or not at a very low number. Mm-hmm. So this is why it's extremely important for the laboratory analyses of any investigation also include, and usually they're printed out in data tables that show sample number and what was found, and then the quantitation limit. Otherwise, you don't know if the method was sensitive enough to actually say that the contamination found was above or below the key number, the MOTCA cleanup level. So that's a lengthy answer to say, no, absolutely not. When we're having an investigation of this, anyone absolutely who's reviewing this is going to say, without data, this is not a sufficient report. Now, occasionally we'll use summaries when the data has been previously reported, which in this case they have not. My understanding is that the investigation was completed over a year ago, so it's not that Farallon hasn't had enough time to actually assemble the detailed report that provides all of the data needed to determine whether the investigation and the laboratory analysis were sufficient to determine if the contamination is above or below MOTCA limits. And so I'm surprised that he said that, but there is a function for summaries. There is, but not in this case. In my view, I was frankly appalled that they did a new investigation and the data still have not been published. I've never seen that before. So while we're on this topic, planning area 1, I just want to make a comment about the size of that area, just to kind of bring it into a way we can sort of get an idea. I don't know how many of you all have been on the site. I have not. So I need to use these mental exercises to imagine it. The planning area 1 is 102 acres. That is equivalent to 77 adjacent football fields, including the end zones. 77 football fields. Now, imagine that you're sitting in the stadium of a football field and there is one pit in the middle of that field that may be 40 feet long and 10 to 15 feet deep. What would you think that pit, test pit, can tell you about the quality of the soil? In other words, its contamination level for the entire football stadium, or the entire football field. So in my mind, I see this pit and I could, imagine several soil samples being taken at depth. And at each one of those depths, we get a number for whatever the contaminants are that are being analyzed for. But it gives me no information whatsoever, even 10 feet away from that pit, let alone in the end zone, if this pit is in the center.
Okay. Just to clarify, there were 9 test pits, I believe,
Yes.
for this site. So we're talking 77 football fields, 9 test pits. That would be roughly 1 test pit for every 8.5 football fields.
That's correct.
Okay. All right. So it would be 8 football fields with 1 test pit.
Right.
Okay. All right.
Right. So the question is, was that sufficient in terms of a remedial investigation? And I would posit that absolutely not. We have 8 pinpoints, if you will, of information regarding soil and sand and groundwater across 102 acres, across 77 football fields. So that is not, in my view, a comprehensive investigation. It does give us some information, but it can't possibly be considered complete.
Mm-hmm. And in your opinion, would ecology consider that complete?
No.
And right.
So let me continue with things that were found in that investigation. They found in the test pits, they didn't tell us which test pits, we don't know if it was all of the test pits or some, that there was wood waste fill. Not a huge surprise, but it would have been helpful to know at what depth that wood waste began or ended within the vertical dimension that the test pit was looking at, and what the composition was. Typically with a test pit, there is also a diagram, 2 diagrams actually, and a photograph of test pits that are noted right there in the field, and then go back and do the computerized version. But the usually a geologist or hydrogeologist is logging by depth his or her observation of the soil type, color, etc., so that the lithography of that soil column is recorded on both sides of the test pit. Without, again, that piece of data, or those pieces of data, were completely missing from this investigation. And it's like, well, that's great information, but we didn't get the benefit of it. The other thing that they look for is, when does groundwater appear? And that's a very significant piece of information in each test pit. Also, the investigator looks at whether there is a sheen on the water when it shows up, if it does in the test pit. A sheen typically indicates there is petroleum contamination of some sort. It's not always petroleum contamination, but most often. So missing that data, we lost a lot of information that would have been helpful to understand what's really in the subsurface within this 77 football field sized site.
And apart just from that being important for ecology, would that information have also been helpful for the city or a decision maker making a decision about this site?
Yes, and there are many decisions that would be enhanced by having that information, not the least of which is the developer himself, who needs to know what the quality of the soil is in the subsurface, where the wood waste material is in the subsurface, and the lateral extent of it. There wasn't anything said about lateral extent of that woody fill in planning area 1. I think that's an extremely important question that was left unanswered, which also means this was not a sufficient analysis of planning area 1 to qualify as a complete remedial investigation. We have 9 little pinpricks in that area where we have a tiny bit of soil information, but even what was probably gathered, we didn't even get the benefit of in terms of the soil test pits. They also, in that investigation, another thing about the wood waste in soil is that wood waste decomposes in soil, and having an idea through visual analysis or even microscopic analysis of how far that decomposition has gone is also would also be helpful information. The fill was noted in the report to be found as deep as 16 feet in 1 or more of the test pits. That's pretty deep fill. So this was likely a very large, it could have been a large quantity of fill material. Again, without knowing the lateral extent, we have no information to quantify that over the breadth of this 102-acre site. And by the way, from experience, from information I have read regarding other mill sites that have been through or are undergoing remedial investigation, it's very common to find woody fill, and it contains typically bark, wood chips, and sawdust. So it's stuff that's generated in the process of sawmilling, and it's very common in these type of sites across the state. So let me address then groundwater samples that were taken at this site. There were, I believe he said 8, the report says 8 groundwater monitoring wells, essentially at 6 locations. So at 2 locations, there was a deep well and a more shallow well side by side, so that the 2 bodies of subsurface water could each be sampled independently, which is helpful. It's because they, as I believe Mr. Schmidt testified, contaminants in groundwater migrate sideways, laterally in the subsurface, and not much up and down, although that's not quite true. Some contaminants will actually sink to the bottom of the aquifer, and others will tend to float closer to the top. So, but in terms of the potential for contaminating other areas laterally, it's important to know that they're there because that's the movement of the water. So if the contaminants move with the water, you will see a plume, or you can document a plume of contamination. Mm-hmm. So in this case, we have these individual wells located near the boundary of planning area 1, and they were sampled a single time according to this report, the summary report provided in Appendix B. Groundwater, as I mentioned before in my testimony, is a dynamic environment. The groundwater is always moving. It responds to the amount of rainfall. It responds often if it's in connection with the river or another body of water, as Mr. Schmidt confirmed that the groundwater on this site is in connection with both the river and Boris Lake, then it's important to see.
Objection. I think that mischaracterizes Mr. Schmidt's testimony. Sorry, here's my video. In terms of generalizing what he said.
May I give you the quote?
What I want to do instead is just to note her objection, and I have the transcript. I can look at the exact language for myself. So that'll be fine.
Okay. So ecology requires that there be typically groundwater samples obtained every 3 months on a site so that you can look at seasonal variation of groundwater levels, groundwater chemistry, and contaminant concentrations. That's extremely important information when you're talking about needing to remediate, if you do, contaminants in a large plume or a small plume. So, but there weren't again, going back to 77 football fields, we have 10 monitoring wells at 8 locations. So that's about 1 per 10, a little less than 1 well per 10 football fields. So we do not have very comprehensive. Oh, thank you for the diagram.
You're referring to. Yeah, so this is Appendix B to the FEIS.
It's the final page. Page B, I think, of Appendix B.
Yes.
It's 7. Okay.
Page B7. So these are the 8 wells that you're talking about, where it's really, or is it 1, 2, 3, 4, 5, 6, 7, 8? So 8 monitoring wells, but really 6 locations because these are right next to each other.
That's correct. Yes.
Okay.
Yes. And one of the stated goals, if not the primary goal of this investigation, was to determine whether contamination from planning area 3 or perhaps even planning area 2, although I think that's, can we go back to the figure for a moment?
Sure, yeah, 1 second. Certainly. There you go.
Thank you. So planning area 3 adjoins planning area 1 on planning area 1's eastern border. And there's contamination, particularly right down there near the old plywood plant, that is a potential concern because that plant burned. So there were both leaks to soil and the potential for ash from the fire itself to have impacted planning area 1. So it's interesting to me that there are really only 2 sampling points here that might capture that. That's monitoring wells at location 2, MW2S and MW2, and test pit number 9 just to the west of those. And but again, we don't even have a list in this report specifically of which analyses, in other words, which families of analytes were analyzed for by sample. That is.
Could you break that down with families of analytes by sample? What do you mean by that?
Yeah, okay. So in the laboratory, there are various tests that the laboratory technician does. And within each of those tests, for example, petroleum contaminants, they will find they will test just for the family of petroleum contaminants. That's actually oil range organics, diesel range organics, and gasoline range organics. So it's done by carbon weight, how many carbon molecules are in the hydrocarbon. So that's 3 analyses that can be done. And in that one analysis, you only get reported back the hydrocarbon concentrations within that band. Okay, so you can't find out if there are polycyclic aromatic hydrocarbons from doing a an oil range organics analysis. Okay, they're just different.
Just one second, Ms.
Ms.
Jenkins.
Examiner, and I apologize, Ms. Jenkins, for interrupting. It's difficult to find a convenient time sometimes. Given the time, we've gone through a fair amount of testimony so far. I was wondering if we could get an estimate of how much more time with Mr. Schmidt's availability being limited.
Ms. Clungeon, do you have an idea for how long this will go?
I would say approximately 20 more minutes. So that should work within Mr. Schmidt's availability. He said he was available until 5, so we should fit within that.
But that leaves us no time for cross-examination at all, with Mr. Schmidt still being present to listen.
This is true if the testimony goes that long.
So I don't mean to belabor the point of just, if we can continue to move through this quickly if possible, that would be greatly appreciated.
Thank you. Thank you for making the detailed request. That's helpful.
We will do our best.
Okay. So the question was about chemical analysis. There are several analyses that could be done on any one sample. The report did not tell us which analyses were done for each sample. The report tells us that one or more analyses were done of the following list on the samples, one or more. So it's completely non-specific to any one sample.
So in addition to not even having the data from the sampling, we don't know the analyses that were done to generate the data. Is that accurate?
That is accurate.
Okay. And is that something that would normally be included, or would that be something that would be important for a decision maker or an agency to have to analyze the report?
At this level of investigation, where we essentially know nothing about what may be in the subsurface, it's absolutely essential that we have for each sample as much data as possible. So all this is to say that this might be a great start, but it's by no means a complete remedial investigation of planning area 1. And it does not demonstrate to me that there is no contamination here.
And however, there were some contaminants found in planning area 1, correct?
Yes.
Okay.
Yes.
So the characterization that there's no contamination here or limited is not necessarily accurate. Can you elaborate on the contamination that was present and why that matters?
Yes, what was found is explained on page B1 of Appendix B. And there was arsenic and total petroleum hydrocarbons found. It does not tell us where, and it doesn't tell us in which samples. That is, in my view, a failure. And then it is explained away as the arsenic being, it says the arsenic detected in native soil appears to be representative of natural background conditions. Okay, I can accept that. And not associated with the film material or release from historical activities. Well, I can accept that, but we have no other data provided that shows us any corroboration of that same arsenic level in any other native soil. So if it is a general, naturally occurring metal, you would think it would show up in native soil in more than one sample, right? That was not done here. And they did not say for sure. It says the arsenic appears to be representative. The data suggests that the elevated arsenic concentration. So the report admits that this was not firm or fact. Then they go on to say the elevated arsenic concentrations in groundwater. Again, we don't know how many samples they found elevated arsenic concentrations, but they then theorize that it was because of background conditions or representative of an upgradient source of arsenic off the property. But there was no such source offered So it's like, well, how can you conclude this? We don't know how many samples that this appeared in. If it is naturally occurring, then wouldn't you expect to have found similar numbers in every single groundwater sample that was taken? Well, we don't know because we don't have the data. They also found gas range organics, which is abbreviated in the report as GRO, detected in a single soil sample at a concentration exceeding Matka method A cleanup levels. It is attributed to naturally occurring terpenes produced from plant material. Okay, that sometimes occurs. And there was also diesel range and oil range organics detected in groundwater. Again, we don't know in which samples or at what depth of groundwater, since there are 2 levels in this area. They are also attributable to naturally occurring biogenic material. So it is true that there is a way to do in the laboratory, a way to process the sample that in most but not all cases screen. Yeah, okay, I'm in the weeds. I'm sorry.
Well, and that's okay, Ms. Jenkins. Ms. Examiner, just stating an objection. We're hearing a lot of testimony that could have been presented on direct. We went through this report on direct examination or listened to it with Ms. Jenkins on direct. I'm not understanding the level of detail on rebuttal specifically or the specific issue that she is responding to at this point.
All right.
Okay. I don't really know what to do with that because I understood she was responding to Mr. Schmidt's testimony about the document. I am sensitive about the time. It would be good if we use the time for testimony, I think. So I'll note your objection, but I'm not going to request her to not respond to Mr. Schmidt's testimony about the document.
Thank you. Okay, so
let me just say that when an alternative conclusion is offered that the data don't necessarily support, it should be very thoroughly examined in any investigation. And that thoroughness, in this case, should have included additional sampling and a complete admission of what every sample was analyzed for and what the results were for each of those analytes in each sample, both in groundwater and in soil.
okay.
That was not done.
In your opinion, is the investigation conducted in planning area 1 sufficient to assume that the property is not contaminated?
Absolutely not.
Okay.
Not even for one football field.
Okay. I also just want to bring us to, there was some discussion about there being no evidence of railroad tracks near planning area 1 that you described in your testimony.
Yes. I think
what was the basis for your testimony that there was railroad tracks on or near planning area 1 that needed to be addressed?
In the I believe it's in the draft EIS. Let me see if I can find my my reference to this. No, it was in the it's in the final EIS. It's part, I believe it's let me see if I can find it.
1 second, I might have it here.
Carolyn based their investigation to some degree on a review of aerial photographs that they had done. And they documented that they, in one or more of the aerial photographs, saw a railroad track that crossed, I believe, on the western side of what is planning area 1. Now, it's not in appendix B. I'm so sorry, I'm not finding this. But Brian, show me in paper at the moment.
Let's see, it was page 3-137. Hold on. Okay, it might be in the Historic and Cultural Resources of Planning Area 1 report. Let me grab that.
Oh, yeah, page 137, 3-137. And let me read that section. That's the sentence. Topographic maps and aerial photographs indicate a railroad track accessed the western portion of Planning Area 1 from at least 1917 through the late 1950s. And Mr. Schmidt testified that there was no railroad track in Planning Area 1, that he felt it was outside of that boundary. The railroad track, according to this description, was used to transport logs on and off the site, which makes sense because it was a log storage yard. And to that, Mr. Schmidt testified. The yard was for a long time used for log storage. And they used primarily rail to transport the logs from the area where they were cut down over to the sawmill, and then also to transfer finished product off the site. So I had commented, no, it doesn't matter what I commented, but a comprehensive remedial investigation would have included this as an area where investigation should have been done. There have been many railroad investigations done in the past 30 years where particular contaminants frequently show up. Petroleum hydrocarbons, heavy metals, and those are the primary ones, but also sometimes some solvents. So, so this investigation did not target that area where the railroad tracks had been at all, and that would have been a very useful piece of information. But again, wasn't done.
All right, so are some of my main questions. Okay, do you have, after listening to the testimony today, do you have any kind of additional thoughts or clarifications that you'd like to make before cross?
Let me just address the rest of the site briefly about remedial investigation. There have been, as Mr. Schmidt testified, many discrete sites of contamination which have been investigated one by one and remediated to some degree one by one. And I agree with his statement that most of the contamination that was probably captured in that initial cleanup, but that does not infer that cleanup was complete. And ecology will need to know what is the current status of contamination in all of those sites. And this key question, are there any other areas within planning areas 2 and 3 that are contaminated? That's the hard question. So it's easy when somebody else has already dug a pit and they found contamination and you go back to dig around a little bit more and see if they got all of it. That's kind of easy. It's much harder to then, put on your sleuthing hat and figure out where else contamination might have showed up. And because many of the previous investigations were, more than 10 years ago, some of them 20 years ago.
And did some of those investigations have different standards for cleanup levels at the time?
Yes, they did. And only today's cleanup levels really apply.
Right.
And
we were talking about ecology needing this information. That's one thing, but would it have also is it also important that the city have this information to understand the environmental health impacts on the site for the purposes of the EIS to make a reasoned decision?
Absolutely.
Okay,
Okay. Thank you very much. I think we'll go to Ms. Carey.
thank
No
you.
questions.
No questions. Okay. Is there any cross from the city?
No questions. Thank you.
Okay. Well, thank you. Are we complete then with witness testimony? We are. Thank you so much, Ms. Jenkins, for coming back and for your testimony in this matter.
I haven't had this much fun in a long time.
Well, I'm glad you enjoyed it, and I hope that's true.
All right.
Okay.
Bye-bye.
Bye now. Take care.
Thank you.
All right. We have completed with appellant's rebuttal testimony. Next steps, anyone? Are we done?
We are done.
We're done with testimony. I think we have a couple exhibit issues to deal with.
Yes, yes. Some housekeeping now. I just meant
Yeah.
done with evidence. I just want to take a moment and a breath. Okay. That was a lot. That was a lot of testimony. All right. So I have been receiving the flurry of emails regarding Exhibit S19. I have not read those emails. Shall we just, so I don't know what the current level of agreement or disagreement is, and I haven't seen the redacted document. So I think I'm going to go to Ms. Kaler to start with this topic since it was her motion, and Ms. Kaler, then we'll hear from everybody.
Okay, so we're talking about S19, correct?
Yes, yes.
Okay, and so I did send, I did distribute that around, and honestly, hang on just one moment. I need to do something here technically to be able to share it. If you'll bear with me, can we maybe move on to a different exhibit?
Yes.
And I just need
Yes.
to get it in a computer location where I can share it.
Certainly, certainly. No, yeah, we can circle back. Please, other exhibit issues that are outstanding. Do we want to just go through the master list and address exhibit by exhibit, or do people have particular motions or concerns about specific documents?
I think it would make sense to go through the list.
Okay, let me open it.
And I'll need to make sure that I have the most recent version of that.
I sent one last night, dated 4/7, and I called it day 4 admission status. That was the last document that I circulated.
Okay.
So going through, starting at the top of that, I don't know if you guys all have that list with you, but looking at the lists generally, I believe C3, C4, and C5, we're still seeking determination as to admission, Mr. Sturbank. I think you
Right. I
had testimony
believe that
on those today.
C3 and C4 were admitted. I didn't see a need to continue with C5, so I would withdraw that unless another party wants it in. I don't know if the applicant does.
C5, March 22, 2017, letter from Goldsmith's Trish Clements regarding application. Ms. Kaler,
The applicant doesn't need that one in.
any
been
objections to
superseded.
striking it from the appellants?
I'm sorry, what we're talking about, C4?
5.
5.
C3 and C4 were admitted during testimony.
Okay.
I don't believe we had any testimony to C5.
We did
No.
not.
Okay. 1 second. And you said C3 and C4 were admitted?
Yes, they were.
Okay, all right. Just gonna edit this using your key
Yeah.
here.
Yeah.
Keep it
Well,
clear.
I'll definitely send a completed list after our conversation. So
Okay, perfect.
it's just a matter of any arguments folks may have. So the city is moving to strike its exhibit C5, and we're wondering if you have any reason to keep it in the record. Mr. Bricklin indicates no. Okay, so just
No, I don't.
for consistency's sake, we'll strike C5. I think the next document that was still under discussion was C9, and forgive me, Mr. Schrader, I don't remember because I haven't gone through
Yes,
this.
C9 and C11 came in on with as part of Ms.
Ms.
Campbell's
Campbell's.
redirect this morning.
Yes, that's what I remember. C9 and C11 are both now in. The next documents were resume of Timothy Flynn and Andrew Ostrang. We didn't hear from those witnesses.
Correct. Those can be withdrawn or stricken.
We will strike the resumes. I assume there's no objection to that.
No objection.
So that concludes the city's documents. Did we wrap up the city finally offered documents later in the day? We had through 32.
Yes, and my apologies, I've not had an opportunity to forward those with new numbers. So those would be, sorry, trying to get back to the list here.
Exactly.
I believe we got through C30, so it would be C31 and 32 would be the King County Ordinance and Resolution 1608.
And those were admitted. As was 29.
Yes, 29 and 30 were admitted through Mr. Rogers. 27 and 28 came in through Ms. Campbell. Those were the emails. 27 was the Chandler Felt email, and 28 was the Steve Hershey email.
Great. And again, I will update this list and circulate it. Although that might be Monday morning.
29 was the King County Council Clerk. Ordinance ratification, and C30 was the WashDOT letter confirming Snoqualmie Parkway funding.
Yes. And then 31 was the King County Council ordinance, and 32 was resolution 1608.
Correct.
Yes. All right. Those are the city's exhibits. This morning I keep saying we, it's the royal we, you understand. I admitted the resume of Mr. Schmidt, M3 was admitted. M10. Did we have testimony on M10? I think we did.
Yes, we did.
Yes. So I believe M10 is admitted. And we got through, I'm sorry, Ms. Kayla?
Sorry, I was muted.
So we got through M10, and then I think I have 14 through 17 were previously admitted, and then new exhibits today.
Let's see here. I'm sorry. I had this
know.
written down. So let's see. We admitted M3, correct? We admitted M10 just
Yes.
now.
Yes.
We had M16, which was the Google map.
Yes.
During Mr. Schramm's testimony. And then we had M17,
The red
which
line.
was the red line, exactly. And then we would just have the redacted S19. I do not believe we have any additional exhibits past M17.
All right. So I do want to include applicants' proposed redacted S19 wherever the final version of that falls. That'll help me. That'll make it clear what the motion is. So we'll identify the final redacted version of S19 as M18. And then it's fully in the record. So moving to appellant's exhibits today. As of our last conversation about S8 and S9, I don't think we decided whether there was testimony addressing those exhibits. I don't know what the current
Was
status
testimony
is.
regarding those exhibits in, or at least of S8, like S8. It was.
You said Ms. Jenkins testified to that.
Yes.
Any objections to the admission of S8?
I don't recall that being testified to by Ms. Jenkins.
And I would just agree with that since I was primary with Ms. Jenkins' testimony. I don't recall that exhibit being brought up.
All right. This one is in dispute. Was there any testimony regarding S9 by any witness? I don't recall S9 being cited by any witness.
No.
No, I don't believe so.
Okay, and so the applicant's motion would request to strike that. Any argument against that from appellants?
No, that's fine.
Okay, we'll strike S9. Thank you for that. Did we establish whether there was testimony regarding S14? I can go back and look at the transcript. I don't think S14 came up in my notes at all.
I
A
don't
number,
recall.
a number of these exhibits were foundational for Ms. Jenkins' overview of the contamination of the site. So even though they weren't, explicitly, they weren't brought up as a visual, they were part of her testimony. So I would just ask that we include some of these just to the extent that they're related to the existing contamination on the site and her testimony. And then the examiner can decide what parts of it are relevant if there is a dispute later.
And let me hear from the applicants in response to that.
My concern with that,
Go ahead.
I think both Ms. Kaler and I might have similar objections, but we don't have identification of which exhibits among these Ms. Jenkins actually relied on in providing her testimony. If there are specifics, we would be open to that, but I have not heard specifically which exhibits.
Okay,
And right now we're just talking about S14. And S9 is still in dispute. I have to decide about S9, but right now we're just talking about S14.
And I don't recall testimony on S14 specifically.
Yeah, I don't have it in my notes as having been mentioned.
And I guess we would just object to start out, and apologies, the two of us talking, but to the extent that exhibits were not referenced by number, we had no opportunity to cross-examine the witness regarding that exhibit. We have no idea what part of that exhibit the witness may or may not have been relying on, and it would not be proper to admit it.
All right, and just for forewarning, forecast, I don't actually anticipate announcing my decision on the admission of these exhibits tonight before we disconnect. So I'm going to take your argument and then I will let you know. I'm going to try to distribute a list of what's been completely decided, and I'll probably get that to you Monday morning so that I can be thorough and accurate. And then I will rule on the ultimate admission of the exhibits within a day or two so that we know for briefing what exhibits are in and what exhibits are out. So that's going to be maybe a 1 and maybe a 2-step process where I let you know for sure. So right now the ones under discussion are S9, S14, and of course S19. So far, other than those, so far we've definitively admitted or stricken everything. So we're going to keep going down this list. The next one we did not have any definitive that I don't recall being mentioned in testimony was S22. Was there testimony, any reliance on S22 that was explicit? I don't think I caught that.
No, there was not.
Okay. Do you object to its being stricken?
No.
Okay, well, thank you for that. That makes it easy. We'll strike S22. We had talked about S25 explicitly. Applicants objected to that document explicitly, and appellants requested it be reserved in case there was testimony about it. I don't believe there was. Any objection to its being stricken?
No.
Okay, great. We'll strike S25. Now, with regard to S26 through S31, I don't believe I have heard specific testimony about any of those documents. So here's where I anticipate there being some disagreements. I don't know, Ms. Clinton, can you let me know? I know applicant's motion is to strike all of the documents that weren't specifically testified to. And that motion was made at the beginning of the hearing. And so it should have been in all of our understandings all the way along. I don't know if you have a response to that. Let's just go down the list. S26, objection to it's being stricken.
I have a list from Ms. Jenkins of the documents that she relied on when she prepared her testimony, and S26 is included in that. So I understand that it wasn't explicit, or it wasn't brought up, or sections of, or specific sections that we pointed to, but to the extent that she relied on some of these documents about the contamination and what we know of the contamination on the site, I would just ask that we could maybe consider keeping them in.
Let me ask Ms. Clungeon, did she refer to them during her testimony, even though you did not offer them, or did she not even refer to them?
She referred to potential hazardous waste. She referred to a lot of these, but not the exhibit numbers, and we didn't bring them up and discuss them in detail.
Okay, but when you said she referred to them, you referred to those particular exhibits, not by exhibit number, but referred to the document?
For
No,
some of
Mr.
them, but
Whitman,
not
we
all
were
of them.
specifically asking for those exhibits to be identified, and they were not referenced specifically in any manner that
Right.
would allow us to identify what she was referring to by name of the document or by number.
So I think to the extent that she referred to a document, that would be appropriately made an exhibit. If she didn't mention it by number and there was some uncertainty on the part of the respondents' lawyers, what document are you referring to? They could have inquired about that. But I would agree that as to a document that she used when she was developing her opinions, but she never actually referred to that document during her testimony by number or otherwise, then I would agree that those should not be an exhibit.
So let me just say that I believe that S26 through S31 are all in this gray space now. They all fall within that. And so it's going to fall on somebody to determine whether she actually referred to the content in the documents or the titles of the documents.
Ms. Clungeon, is that something you could do over the weekend on Monday?
Is that something that could be handled in writing?
Yeah, right.
Yes.
Sorry to put that on you.
Well, let's do. So what we'll do, I anticipated there was going to be argument about this, and I've told you all the way along, I thought we would handle it in writing at the end. So what we'll do is I'm going to give you my list, definitely admitted, definitely stricken. And then the ones that are in question, we'll have an opportunity for argument from the appellants and then responses from the parties. Are you going to request a reply? I expect this to be kind of a quick turnaround, but again, we're going to also discuss briefing. So there's some time here, but we need to decide these questions before briefing. So Mr. Sturbank so politely raised his hand.
Try not to talk over people late on a Friday. So thank you, Ms. Examiner. Just a question then, it might be helpful if appellants are going to identify where they believe documents were, a day with timestamp.
Right.
So that the other parties can go check and we can agree or disagree then based on the recordings.
Also, let's all just note that the Zoom meeting videos very helpfully have a transcript. So you should be able to review the transcript and identify where in her testimony and provide a specific reference. There's a timestamp. So that would be, I understand this is a lot of work, but that would be possible to do. So that's what I guess that's what I'm asking for.
So why don't we say by Monday noon? So this is not an 8 a.m. thing.
Oh no, she has to get up. It has to be done by 6 a.m. for sure. Right. Definitely. Yeah, I think Monday noon is reasonable.
Or Monday 5.
No,
I mean,
Monday noon is very reasonable. Yeah.
All right.
So let's just say the other documents that I think fall into the same category are S35 through 37. And did we finally decide about S40? I don't believe there was testimony to S40. I believe the applicant has repeatedly requested it be stricken.
That's fine. You can strike that. We didn't get to it.
Thank you for that. We'll strike S40. S45, 46, and 47 are the only remaining documents that aren't decided. Please, appellants, tell us what category these go in.
45, 46, 47, you said?
Yes.
I'll do the timestamp. I'll include those in that batch.
Okay.
I do believe the Department of Ecology guidelines and voluntary cleanup was brought up repeatedly throughout the contamination testimony. So I'll need to, I would like to keep that. And
so Here's what we'll do. I'm sorry to interrupt you. I'm just trying to, I think that this
Gotcha.
is how, I think this is an effective process. Right now, immediately following the call, I'm going to compile the list of documents that are up for discussion. I will send it to everybody. By noon on Monday, Ms. Clenchen will give us her response as to where it was referenced in witness testimony sufficiently to merit not striking based on the motion. And then we'll have argument. So then we need argument. So appellants have made the argument, it should be admitted. We'll allow the other parties to respond and we'll have a reply. So can we do this in like a couple of day time frame next week so that we know for sure by Wednesday, which documents are in and which are out?
Sure. Why don't we say any objections to that come by noon on Tuesday, and we'll get a reply in by noon on Wednesday.
I think that sounds very reasonable. So then by wait a minute, let me look at my calendar.
It'd be the 13th.
Wednesday is the 13th. By noon, so I have hearings that evening at 6 p.m. If I get your objections by, yes, I can rule on that before my hearings at 6. So by end of day, Wednesday, we will know what documents are admitted and which documents are stricken. Thank you for working through that process with me. Given that we'll know the record by the 13th, what is the date by which the parties request to submit legal post-hearing legal briefing? And and are we going to do brief argument? Is it going to be simultaneous briefing, or are we going to have appellant argument, responses, and reply?
Just before we get into that, there are 2 other exhibit items. Do you want to?
Thank you. Yes.
At least 2. So first of all, there's the redacted, what is that, C19, I think? And
S19.
S19. So we have to talk about that. And then also, Mr. Durdowski provided a document that has his citations, and I know city attorney had some questions about that. So those are 2 items. Yeah.
Let's complete the exhibit list before we move on to the briefing stuff. So with regard to S19, do you want to have argument about that now? I'm looking at Ms. Kaler actually, because it was her motion and her redacted document.
So I did provide the redacted document to the parties. We had some discussion about it. Mr. Bricklin can correct me if I'm wrong, but I believe we are down to just 2 references to disagreeing about whether 2 references to the comprehensive plan within a particular other issue, whether those are properly in or properly out. So what I'd suggest is I just display those here back and forth on the screen, and then the examiner can decide. Mr. Bricklin, is that right? Did we narrow it down to those things, or there's still other items?
I'm not sure. There was an email from you that
let me share my screen and maybe we can
see what you said.
Let's see here. So this is the redacted version, and Mr. Bricklin, I believe our last exchange was you had suggested that the noise item should be not redacted, and I have therefore included it. I did cross out a line that a couple words that related to the interlocal that is not at issue here. That's that little blacked out area.
Well,
I can
hold
go
on.
back.
Yeah, I have a hard time following it this way because on your redacted version, the whole pages were missing. And so
this is a 9-page document, so it doesn't allow us to see the which pages.
Yeah.
Well, let's start. Let's just kind of run through them. All right.
Yeah, if you wouldn't mind.
Starting on page 1.
Great.
All right. So starting on page 1, it's a cover letter, and it.
I don't care. Cover letter, fine. I don't care about that. You don't want the examiner to know that the historic department was involved in the review. I don't care.
Obviously, the examiner has the whole document.
Or I mean, you don't want it in the record. I don't care.
Just a matter of what goes in the record, right?
Yeah, right.
So on page 2, again, we've got the interlocal agreement. We've got the comp plan.
Well, here's where I get confused. You say page 2. You're on page 2 of the original.
I am on page 2 of the original. Right now I'm going through the original. I was going to go back and forth.
Oh, okay. Because you didn't you eliminate the entirety of page 2?
I did, because it has to do with the interlocal agreement.
Right. Right. But I'm just trying maybe to in part explain to the examiner why this gets confusing, because
Absolutely.
and
Yes.
why I have to go slowly to make sure I'm not missing things.
Absolutely. Sure.
All right.
Yeah.
So we're on page 2 of the original, and you wanted the whole thing out, and there was one paragraph that I wanted to keep in. And have you agreed to keep that one in or not?
I'm pretty sure the paragraph you wanted is on the next page.
I thought it was in paragraph 3.8, related to section 3.83, where it says the FEIS does not demonstrate preservation of rural character.
I thought that what you were referring to was maybe we do have some more disagreement then. I thought that you were referring to what is actually, and again, I apologize, I don't want to scroll with everybody. I thought you had addressed 3.12, which had to do with noise.
I think that was also on my list, but not exclusively. So let me suggest this, given the hour.
Yeah.
And the amount of uncertainty here. Why don't Council and I try to work this out and at least narrow the issues over the weekend and on Monday, and give you a report by Monday noon as to whether there's any issues remaining. I would say one thing. I think the pivotal issue is that several of the county comments state something like, we have a concern about noise, we have a concern about rural character, whatever. And in making that comment, mention that it's inconsistent with the comp plan, or they make some reference to the comp plan. So my view is that on those, the document is relevant to whether the noise, rural character, whatever in the EIS is adequately addressed. The fact that in doing so, the county referenced the comp plan doesn't mean that I'm trying to use this to demonstrate that there's an inconsistency with the comp plan. I understand that's not an issue, but I still think that the document is relevant because it's talking about rural character or noise, even if incidentally the comp plan gets mentioned. So that's where we're having some loggerheads. If you could give us direction on that now, I think we know which way to resolve these things. Otherwise, we'll just present them all to you on Monday, I think.
So
and similarly,
please.
Go, Ms. Examiner, apologies, go ahead.
No, I didn't give you a chance to respond, please.
Oh, I think so. Similarly, in addition to the comp plan, there is a expired interlocal agreement that gets mentioned quite a bit. And the way that these comments are phrased are, there's a violation of this interlocal agreement because here's this provision of it. And I think in this case, it actually might be helpful just to share the screen. And so I am sharing the unredacted version here. And this is one of the items that would be something we would have a disagreement with. The topic is no analysis of consistency with the interlocal agreement in relation to rural character. And the comment then goes on to talk about the interlocal agreement and whether there's analysis of rural character under this particular provision of the interlocal agreement. And our position is the interlocal agreement is not at issue here. Its recitals and exhibits are not at issue here, which is what's being discussed. And therefore this isn't, and therefore this comment would not be relevant. And I think Mr. Bricklin has adequately described the gist of what we're talking about here. So
I'd be happy to stipulate that, one second, just to try to clarify that, I'd be happy to stipulate that it's not being admitted for the purpose of challenging compliance with the ILA or the comp plan. And maybe that would resolve the issue.
Mr. Sturbank.
I would add, Ms. Kaler said part of what I had planned to say, but I would also add that preservation of rural character, or the adequacy of EIS discussion of preservation of rural character, is not an issue in the appeal either. So that in this context, the letter has statements related to the ILA, and then only to that is hitched the rural character. So it's sort of doubly inappropriate. And I appreciate Mr. Bricklin's stipulation, but there, others, it's the record that we're talking about, not necessarily limited to what one lawyer might say about it.
So it's a slippery slope argument, and I get that. We, from the beginning, have struggled to define what is the scope of the appeal, because I think council disagrees with the people who drafted the appeal document about what should be in there, and there's been a tension on this point the whole way through. I've tried to make rulings that are clear, that help to clearly define the scope of the appeal, so that we're all on the same page. That's been difficult to achieve. I don't know if that's just my failing, or if it's just the untidiness of the way this process came together, or a combination of those factors. Yeah. To the extent that the arguments that are encompassed in appeal paragraphs 5, 6, and 7 are still in play with regard to whether or not the land use impacts of this project or the plan as proposed are adequately assessed and mitigated, or discussed mitigation for in the EIS. I don't think that reference to the comp plan, stormwater management plan, the worms, yes, the ILA, anything that was an adopted regulation or plan. I don't think the mere reference to those things opens the whole can of worms to have those things be incorporated into the appeal. But it's a fine, as you all know, this is a fine needle to thread here, and it's slippery. I guess I'm going to ask you to make argument about it, and to do that in our written responses that's coming. I guess, Mr. Bricklin, you asked for direction. I'm poorly trying to say.
Thank you.
I feel like the mere reference to the area that is out, just like when we said there were objections to, for example, Dr. Cook's testimony if the word stormwater came up. Understandably, stormwater is not at issue. Also, stormwater does, in fact, in practical terms, have an impact on wetlands. So therefore, I let her discuss stormwater in terms of its impact on wetlands. Therefore, just the reference to the ILA or reference to the words comp plan don't constitute exceeding the scope of the land use issues that were successfully raised in the appeal.
Thank you.
I'm trying. Mr. Bank, you have a response to this?
And I think it's not mere references to the ILE that are prompting concern. It's that whole sections of this letter are devoted to the county's contention that there's non-compliance with an expired document that's not part of an appeal issue. So I completely understand the examiner's rulings on stormwater and the connection to wetlands, and that made perfect sense. And there were some occasional references. What we're talking about now in this letter is well beyond that type of thing.
I see that argument, and I agree that the ILA, which was adopted but is now expired, that does not inform the conversation to the same extent that those parallel references do regarding stormwater and wetlands.
But on the other hand, I tend to give the examiner way more credit, because I think the examiner can read a document, see that parts of it relate to ILA compliance, which is not an issue, and not take that, not use the document for that purpose. And if it also talks about things that are still relevant, use those parts. And I think about hearsay rulings, and we admonish a jury, let alone a judge or a hearing examiner, well, you may consider that not for the truth of the matter, but for, how it informs somebody else's actions. So the same very words can come in for one purpose and not another. I think we're not giving the examiner enough credit that she can read this document and take out of it what is relevant to the issues that are still in play, and ignore aspects of it that aren't in play.
So I think that the conversation we've just had is all the clarity I'm going to be able to give you with direction for this issue. And then I'm going to ask you to continue to try to work it out. Is noon on Monday still enough time to address S19?
I think so.
Okay. I'm glad you guys are committed to getting that taken care of, because we do want to be expeditious with the outcome of the ultimate proceeding. So S19 was one issue. The other issue was Mr. Dordowski's supplement after the document he emailed, which I did see it popped across my screen, and then I got distracted, so I turned my email off. So I haven't read it. I did skim it and see that there were citations to pages, but then there was also some other information. Do we need to discuss? I understand Mr. Bricklin has offered that as an exhibit. Can I hear from the city and the applicant on that? I guess starting with Mr. Sturbank, since he's unmuted.
Yeah, thank you. Where we left this issue was Mr. Dordowski was referring to particular pages was not clear whether the draft or the final or which pages, because it was a little difficult to hear his audio. So all we asked for was those pages. And there's more on this document. It appears to be quotations from the EIS documents, to which, of course, the city has no objection. But then there's also references and links to an entire staff report packet related to the master program, which it's unclear whether that's being offered or even the relevance, because again, shoreline master program compliance is not at issue in the appeal. Issue 5 only speaks to impacts to growth, not to compliance with the master program or even the facts of the city's adoption. So understanding that ordinances, the examiner can notice this staff report package, besides adding, bulk, because it's several hundred pages long, to the record, it seems to bring in a lot of collateral matters that aren't relevant.
Thank you. Ms. Kaler, care to comment?
Other than knowing the staff report itself is 320 pages, I don't really have anything to add.
I beg you all, please don't put that in the record.
Yeah, no, and we don't need it all in the record. I think the reason he provided that link, and it follows on his exhibit, there were two appendices or exhibits in part of that staff report, which he referred to in his testimony. One was DOE's mandated changes to the master program. That's exhibit or attachment B, and then DOE's recommended changes, which is attachment C. They total about 10 pages total between the two of them. And so what I would propose is we just extract those. That's the part of the staff report that he was referring to.
I appreciate that limitation. Again, I think the city objected to the testimony at the time as being irrelevant and outside the scope of the appeal, this entire issue. And so what we now had, a request for a citation to EIS pages turn into separate exhibits being offered, again, to which the city objects for relevance and outside the scope of the appeal.
Yeah, my understanding was that we were waiting for page citations only from Mr. Derdowski, and that's my preference, is to have it be page citations only. Mr. Bricklin, do you want to make argument in writing to the contrary?
In writing, you said? Sure.
For Monday.
Yeah, sure. I can add a very brief argument as to why that would be useful to have in the record.
So that would make the responses due from applicant and city following noon on Monday delivery of the information also include that. And please refresh my memory. What exhibit number is that? Because I can't find that email now. I might have deleted it.
Mr. Bricklin can speak to that. I don't think it had a number assigned to it.
Right. Yeah, we were just offering it as an exhibit. It would be whatever our next number is. Look to Ms. Klungen for that information.
That would be 52.
All right. So it would be C52 or S52.
Yeah. So the two specific documents that we are still arguing about redacting parts of or admitting are those two. The others are the other lump of documents is documents Ms. Klungen is going to seek verification in the transcript of their being referenced somewhat directly or explicitly enough to merit their inclusion over the objections. So I'm going to send an email that captures that. Again, the Ms. Klungen's responses and arguments on S19 are coming from appellants by noon on Monday. The parties are going to, applicant and staff are going to respond by noon on Tuesday. By noon on Wednesday, appellants will have their final word as the party with the burden, and then I'm going to rule on that before my hearings Wednesday night. That feels ambitious, but I have hearings all day Thursday. So if I don't, it'll be end of day Thursday before I can get it out. So I'm going to try to get that to you by 4 o'clock on Wednesday. I will have been thinking about it. So that means by 4 o'clock Wednesday, we'll know the record.
And as on that redacted one,
yes.
Who goes first on that one? Let's see. I guess
Monday noon.
Yeah, I guess.
You mean S19, right?
Right, S19. I guess I go first, opposing. All right.
Yes.
All right.
Yes. S19 appellants, S19 and what would be S52 appellants are going to give me some written argument for the parties to respond to.
All right. Thank you.
And these, yeah. Sorry to drag it out. I'm a little bit taxed right now in terms of attention. So I'd rather have us do this more well than quickly at this point. So if we have the record confirmed by Wednesday the 13th, shall we do appellant argument responses reply, or should we do simultaneous? What are your, do you care? Do you want me to decide?
As for, on behalf of the applicant, we would greatly appreciate a appellant response reply. I think there have been throughout this hearing various arguments about what the issues are and what's been raised. And I fear that if we do simultaneous briefing, we will be ships passing in the night on some things. So that would be my request.
I think that's right. Does anybody disagree? All right, that's what we'll do. Appellant's argument, responses, and reply. Can we talk about time frame? Mr. Brickland, Ms. Klungen.
I'm going to look to Ms. Klungen. I'm sad to say, Ms. Klungen, it is going to fall primarily on you.
Understood. However, given the number of issues and the length of the record at this point, I would like sufficient time to put that all together.
May I introduce one more variable? Regardless of when this briefing schedule ends, I'm going to be asking for many more than 10 business days to write the findings and recommendation in this matter. I'm really seriously thinking about asking you for 6 weeks. I mean, it's almost the biggest record I've ever had. It might be the biggest record I've ever had. I haven't added the PDF pages up together to know. My biggest record to date was 5,500. So you may or may not be pressing that. I don't know. I obviously you want me to do a thorough job. I don't know how pressing time is of the essence for the applicant, but you want a good recommendation from me and not a quick one. 6 weeks would put me towards the end of May. If we have a 3-week briefing schedule, it'll be mid-June. Can I tell you that it is my preference and intention would be to issue this document by June 10th at the latest, whatever briefing schedule we come up with, because I have family business following June 10th.
That does not sound possible if you need 6 weeks, because that would mean the briefing's done by about 2.5 weeks from now.
Then if we're not talking June 10th, my preference is June 24th at the earliest. And don't trust me, I'm willing to go longer, folks. I'm saying I want to have a solid 6 weeks to review the documents once I'm certain on the arguments. So
Maybe we should start with Ms. Klungen. How much time do you think you need for?
A couple suggestions.
Talk about page limits at all first.
Oh yeah, we had talked King County rules on page limits. But then I think I also said 20 pages in my opening order, and it is 20 pages. A single space 20 pages is fine with me. 20 pages is kind of what I'd be looking for.
Single space 20 pages?
I'd be okay with single space 20 pages.
Okay.
Ms. Examiner?
Yes.
As part of the, to address in part the workload related with the decision, may the parties submit proposed findings and conclusions along with their briefing, may facilitate the examiner's review and decision.
Sure, I'm sure you guys really want to draft those, right, Ms. Klungen? I mean, that may or may not speed up writing substantially. Yeah. And I'm open to that.
And a second point, just related to the length of the record, it did occur to me that one of the city's exhibits, C8, the water system plan, is a pretty large document, and consistent with what else has been happening here, we could propose taking chunks of that out and limiting to the portions that were testified to. Maybe that just adds another layer on this discussion among council, but just thinking about record size.
Well, trust me, I won't be printing it, so that's.
Yeah, and I don't think anybody's printing it, so it probably doesn't matter.
Yeah. Ms. Klungen. Briefing?
Briefing, 20-page single space briefing. Looking at my schedule.
Well, and why you think on that, just in terms of ease on the eyes, can we convert 20 pages of single to whatever the equivalent? I presume it's 40 pages of double.
I don't know the answer to that.
I don't know the math, but I mean, whatever. I guess I'd rather read double, double
If that's
space.
the preference, that's fine with me. I always write single space documents, so that's just my default. I'm looking to create a limit, and if 40 space double is 20 space single, that is fine with me.
I assume it's close, if not precise.
Okay, we've gone to 40 pages double. Whew. Oh, the level of detail here. Okay. Give us
There's no objection.
no.
I'm looking, given that and my schedule, I'd like at least 2 weeks to try and put all that together and coordinate that. So I'm looking at sometime in that last week of April.
Shall we stick with the Wednesdays and just keep it on Wednesdays, April 27?
Sounds good.
How long to
Apologies,
respond?
Ms. Examiner, would it be possible? I think that's a little bit over 2 weeks. I'm just flipping back and forth to my calendar here.
Well, it's
think
2
2
weeks
weeks-
from when, two weeks from when the exhibit decision
Going
comes
Oh,
out.
thank you.
Wednesday,
Yes,
so
got it.
I'm
Yep.
basing it off of 2 weeks from that.
Yes, and that was my intention.
Okay, thank you.
Do the parties request 1 week to respond or 2 weeks? 7 weeks?
If
I
that's
thought it
an
was gonna-
option, I'll take that on the first round.
Just kidding. Just kidding.
I thought it was going to be noon the next day.
Yeah, right, exactly, exactly. I'm gonna let Mr. Cartman respond to that.
Cartman.
To whether we want 1 or 2 weeks to respond to the brief that we are going to receive.
I'm sitting in the dark. Sorry. It is Friday evening.
You're fine.
Okay, either way.
Okay, well, let's play this out and just see how it interacts with your schedule, Ms. Examiner.
Sure.
I think, well, and I suppose I don't want to speak for the city on their timing, but
Well, I agree. I'd like to see how it plays out. And I'd also make the observation that just circling back, since I didn't have a chance to jump in on, we went quickly from 20 pages to 40. And I won't object to the 40 so long as we have a commitment that it's going to be adhered to, and we won't get an overlength with a request to allow overlength, because that's going to compromise our ability to quickly respond.
Yeah. Well, yeah, we'll have 40 pages. I just stopped reading, so it will be wasted effort.
Understood.
so will a week work for a reply?
I'm sorry, did Mr. Cartman say 1 or 2 weeks?
For a
Mr.
response or a
Cartman?
reply?
This is a response.
I believe Mr. Cartman said he was good either way, so we'd just like to see how things play out. Let's say, so we're looking at the initial brief being due on the 27th.
Yes.
Then if we, what if we were to split the difference and then have the 6th for that? I'm looking at the calendar correctly.
Yep. May 6th response is about 10 days instead of 14. Yes.
Yeah. And then what if we have a week for reply, which would be the May 13th?
13th.
And then we end up with, a little less than a month to June 10th, right? I guess that is a month to June 10th. Or 6 weeks to June 24th.
24th. Yeah.
And let me ask also, I assume the page limit is not being split by the 2 respondents, so we'll be responding to 80 pages, not 40 pages. So we may want more than 7 days to read, let alone respond to 80 pages of material.
If we get a response on May 6th, I mean, when we get the responses on May 6th, are you thinking May 18?
Yeah, that's exactly the date was looking at.
Go back to Wednesday. I still like June 24 for the decision, though.
That gives you 5 weeks or so, or close to 6 weeks.
And can I just clarify, since we have opening, response, reply, are we, what would the page limit then for the reply brief be? I'm assuming we have opening 40 pages, or are we splitting between opening and reply that 40 pages? How are we doing that?
Well, 40 pages for the opening brief, and I don't know. Reply briefs are typically shorter. Shall I make it shorter?
We normally, I mean, very common, it's half
Yeah.
of the response brief. So we would have a 20-page response for each of the 2 briefs. So it would total 40 pages.
That seems just to me.
And may I suggest that if the applicant and city are very concise and we do not take up all our full 80 pages, perhaps we could have the reply similarly reduced, and I'm sure the examiner would thank us all.
And we would thank you.
Yeah. I would. Yes. Please do not review these limits as minimums.
Right.
But now that we're looking at playing it all the way out that way, I'm going to go back to my request for 6 weeks and suggest July 1 for the decision instead of June 24. It's just one additional week.
That's the applicant's call.
Yes. Response to that from the
I'm sorry, I was not speaking to that question. Go ahead, Ms. Kaler. Sorry.
Oh, yes, no objection.
Thank you.
That
Thank you. Mr. Cartman, you did want to add something?
I
just had a
I'm sorry, the city wanted to just add, so Ms. Examiner, since this proceeding has another part which involves city council,
Yes.
This further we get into summer, then it gets harder for the council to consider this in a timely way before fall budget season. So I just wanted to raise that as a consideration on timing.
And is July 1 going to meet that need?
It will make it tight. Of course, if we can submit shorter briefs and it happens faster and we have that, we just agree to that date, that's fine.
Well, and let me just tell everybody, I commit to issuing the decision before that if it's done before that, obviously. And I might surprise myself and not need that time. Unfortunately, this is not the only matter I have going on in the next 6 weeks or 3 months or whatever. So please let me hear, Mr. Cartman, you had an input.
Not on this question. So if
Right.
there's anything left to resolve about the schedule, I don't want to interrupt.
No, please go ahead.
I was going to ask at one point, Ms. Examiner, I believe you referenced a transcript. I think we're all used to listening to recordings and finding testimony that way, but if there's any chance that speeds things along, if there's something to look at, or if we could all be looking at the same thing.
It's the Zoom recordings of the meetings has a sidebar that shows it's a auto-generated transcript of testimony. It's definitely not perfect, but it's pretty good, and it will give you a link.
Does it appear in the recordings? I noticed that it was in the live PCI hearing the other night, but had not seen it in the actual hearing video.
I only opened one of the hearing videos to test that it was there, but it was there.
Thank you.
So I assume it's there for all the videos.
Thank you.
And that, Mr. Rogers?
Thank you, Ms. Examiner. To clarify, Mr. Cartman, the direct Zoom links that we've been circulating at night do have that transcript available. The recordings that the city is posting to YouTube do not have that. So you'll have to go through the Zoom recordings for that.
Yeah.
Okay.
And note, there's a passcode. You have to use the right passcode to get in each recording. But it's in the emails that Mr. Monroe has been sending every night.
Very glad I asked.
And it's my favorite thing about Zoom.
Yes.
Well, that and not having to drive to Snoqualmie 6 days. That was also lovely.
Ms. Examiner, if I can revisit schedule a little bit in light of Mr. Sturbank's very helpful comment, which I probably should have been taking into account. I would like to propose that we have a shorter page limit, that the applicant take a week instead of 10 days, that we move the schedule up, because I think this is really a very, very large chunk of post-hearing briefing time, and that if we can do that and we can hopefully then accelerate the decision in this matter, we would certainly appreciate it. I think I understand that we're getting a ruling on some of the exhibits on Wednesday, but also at the same time that those things are not going to be, I think there's probably quite a bit of briefing that can be done without knowing the result of that. So I'm wondering if we can have the appellant's brief due the 22nd, the applicant's response due the 29th, and then the reply due the 6th of May. And I think we could reduce the number of pages as well and be pretty reasonable.
So that shaves 5 days off of that initial request for a 2-week period.
Right. May I be heard on that? I mean, as the examiner has other matters, so do we all. And it's, to save 5 days. I didn't hear from the city that 5 days was going to be critical in terms of avoiding their budget crunch and all.
Let me just stop this argument and say I will commit to a June 24 decision deadline rather than shave time off at the top, because I can also start before the briefing is all done. So I mean, and trust me, the document template's already under construction. So yeah, so I will go back to June 24. And Mr. Sturbank, is the 1 week going to help that concern?
It does help, and thank you, because there are statutory deadlines related to the budget that trigger a bunch of things, and
Sure.
So
let me go. Sorry.
Thank you.
Sorry, just to go back over that date. So we're going to stick with the page limits, or are we going to change the page limits? I think I'm fine with the 40-page page limits. It's the number of pages I have to read is nowhere near as important to me as the salience of the arguments. So shaving pages off isn't going to make your arguments necessarily better. So let's stick with the 40 pages and the 40, 40, and 2020 that we previously agreed. And then that schedule again is appellant brief the 27th, applicant and city response May 6th, appellant reply May 18, and then decision June 24. Whew. Okay. So, and then at the top,
sorry, could you read those dates one more time, please?
Yes, sir. Yes, sir. And I will email following this too, but just for the sake of making sure we're in agreement. Appellant brief April 27, responses May 6, reply May 18th, decision June 24.
Thank you.
Yes. And backing up to the earlier, by noon Monday, we're going to have argument in writing from Mr. Bricklin and Ms. Klungen about the proposed redaction on S19 and how much or what to let in from Mr. Derdowski. We're going to have that by noon on Monday, and by noon on Tuesday, staff and the applicant are going to let me know what they think about that. And I'm going to have a reply from appellants by noon on Wednesday and rule on those 2 documents and the list of ones that Ms. Klungen is seeking proof that they were addressed in testimony for by 4 on Wednesday, April 13th.
Have a nice weekend, everybody.
Yeah, I believe that's our whole schedule. I'm going to try to write that all out right now and send it to you right now so that you have all that. I will do the fully revised list and have that for you first thing Monday morning.
Thank you.
Business?
Yes.
Let me just check in with everybody. Appellants, any other business before we adjourn?
No, other than to thank you, of course, for wonderful management of this unruly crew.
Wonderful might be stretching it. Ms. Kaler, Mr. Cartman, anything further before we close?
Nothing further, thank you.
Okay, Mr. Sturbank?
No, thank you, Ms. Examiner, and thank you to all counsel for the courtesies and as Mr. Bricklin said, in getting through this process.
Yeah.
And also to your staff, as has been mentioned before, they did a great job.
Thank you. I said it earlier and I meant to say it again. It's been extremely, extremely helpful to have prompt and timely assistance with Zoom and also dispersal of all the emails. It's been great. You guys have been great. So, yay team. Okay. Thanks. Seriously, thanks everybody. It's an honor to participate in this very important proceeding, and I will be shooting you an email now. We adjourn. It's not even 6. Dang, we are good.
So long.
Have a good weekend.
This weekend, everyone.
Good night.
Take
Thank you,
care.
everyone.
Everybody
Bye-bye.
stay well.